Yes.
Transfer matter, my lord, I am going to listing it tomorrow, my lord, for motion.
No. Friday.
On Friday, my lord, I have some personal difficulty. my lord.
That can't be helped. Tomorrow, not unlisted like this. Transfer matter.
Yes, sir, tomorrow, my lord. Friday, my lord, I have some difficulty.
Then Monday,
I will
then
be out of station.
why do you make mentions like this? You know, motion day, hearing day, etc., etc. Then
Tomorrow, my lord, motion day, my lord.
tomorrow is all right, but it has to be listed subject to correction. Huh? When was the order passed?
Uh, Order was passed in the month of August,
Then what is the urgency?
Monday, my lord.
Not Monday. Monday is a holiday. So let it come in on 19th. 19th or when are we opening? 19th.
Before you, my lord, if possible, my lord.
No, before
Tomorrow or
Bihu,
day after
we
tomorrow,
can
my
give
lord.
you only 12.
Tomorrow or day after tomorrow, my lord.
Mr. Counsel,
Yes, ma'am.
your transfer order was issued in August.
But he is not getting the current salary, my lord. He has not been released by the my lord, SSA, my lord.
Whatever it may be, it was passed in August.
Yes.
We are in January. 6 months, whatever he has to suffer, he has suffered. Wait for another 1 week. Let it be on 19th. All right?
My lord.
Yes.
May I please, your lordship? With the consent of other side, I beg to mention item number 26, your lordship. This matter may come up after Bihu vacation, your lordship.
26.
Yes, Lordship, 26, Lordship.
You are for the
I'm for the petitioner.
petitioner.
Mr. Jalan is having some problem in his eyes. That's why he requested me.
Okay.
Lordship, may I pray, Lordship, let it come on 23rd after the Bihu.
See, once a matter is fixed and you agree to an adjournment, then it's
I didn't
difficult
know
to give
any
you
other
an
way because he's put a absence list, so his name is there.
23rd.
Lordship, 23rd, Lordship. After that, I'll be not there.
What is the issue? What is the matter
Lordship,
about?
he's under, he's been sacked from service. He's no more in service. I'm challenging the department proceeding order, Lordship. Last time also I took it very,
See, we are conscious that matters will have to be heard. Now, if you look into the list, you will find there are matters of 2012.
Lordship, I understand.
So you will have to have a justifiable reason to give a
The
precedent.
last time Lordship had said today, it was, I agreed, Lordship. Please, Lordship, on 23rd, Lordship.
23rd, 20, let it be on 25th.
20.
You're out of station.
Yes, Lordship.
When are you back?
I'll be back in February, Lordship.
So, any date, choose a date in February?
January 20. Let it be on 25th, Lordship.
25th, all right. At
Okay.
the request of, joint request, matter stands listed on 25th of January.
Most obliged, Lordship.
Obliged, your lordship.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 42, Lordship. We have circulated an adjournment slip, Lordship.
Item 42.
Yes, Lordship.
As per the adjournment slip circulated, matter stands adjourned for 3 weeks. Yes.
May I pray for fixing a date after vacation, Lordship? Bihu vacation. Lordship. Any date?
No date. It will come as and when after vacation.
Much
Yes.
obliged.
May I please, Your Lordship,
Yes.
I'd like to mention item 8.
Item 8.
Yeah, it's a part of matter, but Lordship, the PK Tiwari sir who is leading the matter is not well, and his intimation of absence is also reflected in the cost list. Kindly accommodate us after a week.
After a week.
Yes, Lordship.
We'll have
For
it in February.
convenience of the Lordship.
1st of February.
Obliged, Lordship.
May I please, your lordship?
Yes.
I'd like to mention for listing on WPC 627823 with I
Or for admission. Orders.
orders for
Or-
along with IA.
For orders.
Yes.
Give it.
Even Friday.
He'll try. Yes.
May I beg your lordship? I beg to mention item 45, lordship. Hearing, lordship.
45.
The engaged counsel is out of station, lordship. Kindly the matter may be fixed after due vacation or in the month
On behalf of the petitioner.
Yes, lordship. As Biswas.
It is submitted on behalf of the learned counsel, Mr. S. Biswas, that he is not available in court. The counsel is prayed for an adjournment. List in the month of February. Yes.
Much of
Yes. Tejpur.
My lord, there are two items.
Yes.
While the item number 2 was pending before this honorable court with certain interim order, certain other actions were also taken by the same respondent. Therefore, item number 1 had to be filed, my. I, my lord, in both the cases, my lord,
Hmm.
the series of orders were passed at the motion stage. Notice of motion not yet issued. Now,
Now, item 2 is for direction to change the presenting officer.
and also, my lord, I challenge the disciplinary proceeding also, which your lordship state, my.
Now, we have stayed, but essentially your prayer is, you are aggrieved by the appointment of the,
My lord, have a look at the cost title of the writ petition.
no, look into the prayers,
Yeah.
your prayer.
My lord, therefore, in that case, my lord,
You are challenging the
Yes.
order for appointment of the presenting officer.
then, my lord, in the cost.
And therefore, according to you, if the presenting officer is biased,
No, both of them were, my lord, replaced. My lord, the
Ah.
lordship may kindly have a look at, I'll, the cost title, my lord, impugn memorandum.
Hmm.
3, my lord.
yes,
It's an implemental file, this settlement. I'm sorry, I'm secondly wrong file. Yes. My lord, lordship may have a look at, for that, my lord, actually, page 3 of the cost title, impugn memorandum dated 26/11/20 bearing containing article of charges against the petitioner. My lord, by this impugn memorandum, actually the disciplinary proceeding was initiated.
Hmm.
And in paragraph 22, I said, paragraph 25,
now what is the stage of the disciplinary proceeding?
my lord, that has been said by your lordship, my lord.
So after filing of, have you filed a reply?
Where, my lord?
Have you filed a reply?
Yes, my lord, that was, that I
But
filed, my lord.
evidence has not been adduced.
No, not yet been, not yet been done.
Hmm.
And meanwhile, during the pendency, my lord, they stopped the increment, therefore the other case was filed.
Hmm.
Now, if your lordship wants to dispose of both the matters, I am at the disposal of your lordship, but I will have to argue for that. And so far as this was concerned, one IA was also filed, my lord. And my lord, lordship kindly turn to the prayer portion.
Hmm.
In the prayer portion, my lord, at page 22. Page 22 of the writ petition.
Item number 2.
Yes,
Yes.
2209. My lord, here, my lord, inadvertently, the Annexa 11 was, my lord, mentioned twice.
Hmm.
Annexa 11. Actually, my lord, therefore, my lord, I filed an IA that was in October 2023, my lord. This IA, not that, my lord, a few days back I filed. It was also not disposed of pending. Here, my lord, paragraph 5 in the IA,
Hmm.
I made a prayer for insertion of, my lord, in the second annexure 1 repetition, insertion of the following sentence, namely an impugn memorandum dated 26/11/20, bearing number so and so, containing article 3. That was my IMI. Paragraph 5 of the interlocutory application.
All right. Then you have to, Mr. Gogo is filed an IA,
Lordships, this IAS file in at the hearing stage, Lordship.
whatever, not hearing, motion.
No, Lordship. This matter was in the hearing list.
Huh?
Now it is take with the motion, yes, because the other matter is not issued, notice was
Okay,
not
okay.
issued. This matter was originally in the hearing list, Lordship.
No,
Hearing-
cannot
hearing-
be in
hearing
the
column.
hearing list. Notice of motion was not issued.
It's
Even
a
today.
hearing, it's a hearing column, Lordship.
No, hearing or otherwise. Now the
Right.
question is, these
Right.
sought for an amendment
Lordship.
in the IA.
Lordship.
So if you object, then we'll issue notice, you file your objections, whatever is.
Lordship may finally dispose of the matter, Lordship. The
Yeah.
disciplinary proceeding is pending, Lordship. Lordship may hear today and dispose of it, Lordship.
What to do with the
Even
IA?
Lordship-
What is to be done with the IA? There is an IA praying
Lordship.
for
In the
insertion.
main litigation, Lordship, the pair is not there. Even Lordship.
No, we are referring to the IA.
Yeah.
IA 3279.
Lordship may heard together all this,
Ah.
all the three petitions, Lordship.
You deal with the IA first, There's an IA file,
Take it
we'll have to
ahead.
pass some orders on the IA.
Hmm.
Have you served a copy on them, the IA?
Definitely. Otherwise it is not coming.
এইটো বুজি পাইছো এইটো ভিতৰত নাহে না হিয়াৰিঙত আহিব এইটো
Hmm.
লৰ্ডশ্বিপ
They have filed an IA,
লৰ্ডশ্বিপ
so we have to pass some order on the IA.
লৰ্ডশ্বিপ
Now, either we allow the IA asking them to insert and then we can hear the matter.
লৰ্ডশ্বিপ
Or if you want to object that this is not permissible or not required or whatever the reason, then you'll have to file your objection.
admittedly it was in the lordship when the matter was in the hearing stage lordship.
But
Lordship.
amendment at any stage,
Lordship.
It was filed in
before
October.
delivery, before conclusion of
Filing
the
is
hearing.
the issue what
No, filing, it
Still,
was not filed,
I am not saying
filed
that it is
yesterday.
not- I am
It was
not
filed-
saying that it is filed yesterday, it is filed in the December, it is filed in the month of November.
Before
I-
issuance of my lord notice of motion, it was filed.
My lord may kindly peruse the order sheet
No.
lordship. Kindly peruse the order sheet of this court lordship when notice of motion was issued in this particular lordship WBC 2209 lordship and when the I was filed lordship.
So that's all right.
Lordship.
Uh,
Notice of motion was issued lordship on 26/3/2021.
no, now you want to pass some order in the IA, you tell us.
Lordship may pass the order I lordship and finally hear it lordship.
No, if we allow the IA, then the amendments will have to be brought in.
Lordship. My
you have any-
objection is that lordship at the time of hearing stage lordship the pair cannot be amended lordship.
Show us any authority.
Lordship.
You
And
show us
then-
any, on what basis are you making that?
Lordship.
Do you have any authority to?
Lordship, I have the authority in respect of lordship, the pair was not made that cannot be entertained by the honorable court.
That's all right. Therefore, they have filed an IA
Lordship.
to implead. Now, if you want to object, we
Lordship,
give you an opportunity.
after we are, after the matter was in fact was, they have filed the IA. Yes, because their pair is there to lordship, since the lordship presenting officer,
You file all that in the objections if you want.
lordship. Their main pair is lordship, my lord may kindly page 22 lordship. Their pair is for lordship, the issue
We have seen it.
lordship.
Now they have filed an IA.
Lordship,
If you want to object, we are giving you opportunities to file your
Lord-
objections.
as and when lordship, just I am narrating the facts, as and when lordship, we have withdrawn the lordship letter whereby presenting officer was lordship appointed and he was sent. Then they have come with a IA lordship for change the lordship pair lordship.
So you file your objection.
Lordship.
Heard Learned Council for Parties issue notice. IA, in the IA 3279.
Otherwise, lordship may, it will delay the matter. Lordship may allow their IA lordship. Even allowing the IA also lordship, that will not do lordship. Lordship may allow the IA and lordship may hear it lordship.
Okay, heard Learned Council for the parties. This IA has been filed by the petitioner seeking amendments in the writ petition WPC number so and so. By the said IA, the petitioner seeks amendment of paragraph 25 is under. There are three quote. And sorry, 6 amendment of para 5, amendment of the following sentence. It's quoted from para 5. As well as a corresponding amendment in the prayer of the writ petition, made in the writ petition para. Mr. K. Gogoi Learned, CGC appearing for the respondents does not object to the prayer made. Accordingly, I stands allowed. The petitioners are permitted to make necessary amendments in the matter and file a complete amended writ petition before the court. You have to file another amended petition
Under the High Court rules.
under the rules of the court and furnish the same, furnish advance copies thereof to the respondent authorities. Let the matter be listed on 30 January
Lordship.
for be listed on 30 January.
Lordship may indicate so final disposal lordship. Otherwise, lordship matter is pending lordship since 2021 lordship.
in this matter was listed for motion, as this matter was directed to be listed with WPC, as WPC 5622 was directed to be listed along with WPC 2209.
Now, along with my lord, 5622. Lordship is passing order in my lord 2209.
2209.
I is connected there too.
Uh,
So it has to come with the second case, my lord, 5622.
5622.
Yes, my lord, this was in fact kept part heard by a court, my lord. That's why, my lord, both the cases were segregated. That was released from part heard. Then, my lord, last time your lordship ordered both the cases to be listed. Obliged, Lord.
In 5622, no notice was issued.
My lord, I think no.
All right. Then
No,
take out in 5622, you write this writ petition was directed to be listed along with 2209.
The second
Not
case,
you-
my lord, they have, in fact, second case, my lord, lordship may issue notice, my lord, no fresh state necessary.
Since this matter is connected with WPC 2209 2021, the matters are directed to be listed together. Stop. In WPC 5622/2023, the notices were issued and the matter was listed or is required to be listed for admission accordingly. In this writ petition also, let notice be issued returnable on 30/01/2023.
No fresh state necessary.
Since the councils are represented and copies have been and copies have already been served, no fresh steps are necessary. List both the writ petitions for admission on 30/01/2023.
My lord, may kindly indicate, Lordship, that endeavor shall be made to dispose.
Admission hearing.
Lordship.
All
My
right.
lord, there are continuous interim order.
Lordship may kindly indicate that part, Lordship, otherwise.
Interim order passed earlier in
2209.
WPC 2209 will continue till 30.
Lordship may indicate endeavor shall be made, Lordship. That part,
Okay, that is why we have listed it for admission hearing.
Lordship.
It will be listed for admission hearing.
Lordship.
If we admit, we admit. Otherwise, we dispose it off.
Lordship, Lordship. No issue, no issue. Apologies.
May please, Your Lordship. Petitioner is the second wife of the late Zainal Abidin Sheikh. Earlier occasion, the Honorable Court directed to respondent to obtain instruction, my lord.
Yes, respondent, who's there?
Lordship, we are yet to receive instruction. in this
What
matter.
instruction? It is covered by the full bench judgment.
Yes, Lordship, then Lordship
Then-
may pass an order, Lordship.
Have you approached the authorities?
Yes, my lordship, we approach the authorities.
Where is that application?
Page number 24, my lordship.
24.
Petitioner unmarried daughter was filed an application representation.
You are who? The second wife.
Second wife, my lord.
Then have you filed an application?
My daughter is filed application. Two application has been filed, my lord. Thereafter, there is an agreement executed between the first wife and second wife to
A full bench judgment was it? Huh? Pension, 45 second. We are disposing it off with a direction to the
Lordship.
respondents to address, consider your claims in terms of the directions or liberty granted in the full bench order. All right? We'll take it up after a while, let the judgment come.
Yes.
Yes. But be around, we'll call up the matter. Yes.
Matter relates to the prayer for the petitioner for pension, being unmarried daughter, my lord, sole survivor.
Ah.
And there was order for take instruction, my lord.
Yes, yes, instructions.
Lordship, one instruction has been sent, but it is a wrong one, Lordship. They have, I think inadvertently, some other has been attached here in this. Lordship, may kindly take it up on or 18th or 17th, Lordship.
Why for these small instructions, why
Lordship.
person is running from
Logically,
pillar to post for pension? There seems to be no difficulty in granting the
They
pension.
have sent Lordship, Lord, but this pertains to another case, Lordship.
You get it on Friday. Can you get it
Lordship.
on Friday?
Lordship.
Matter be listed on Friday again as the learned government advocate, MS Bhattacharjee, prays for further time to obtain the required instruction. Mr. S. Biswas appears for the petitioner. List on Friday for
Deeply obliged, Your Lordship.
instructions to be furnished by the respondents. Mr. B. Chakraborty for Accountant General.
Please, your lordship,
Yes.
petition lordship for transfer lordship is discharging her duties lordship 200 kilometers from her residence lordship. Yet for post lordship, she has been appointed in KTR Memorial School lordship in Kamrup Metro Amsing lordship. And now she wants to transfer to the Vidya Niketan Mongoloi lordship.
Yes, education.
Lordship, here, in fact, this is the second round of litigation. In earlier round of litigation, in WPC number 7337 of 2022, there was a direction of this honorable court to apprise as the status of the representation preferred by the petitioner lordship.
Hmm.
That representation received by the director has been forwarded to the government
Hmm.
for necessary instruction lordship, because this 2028 for transfer and posting of teachers is not applicable to the grade 4 employee. So that representation has been forwarded to the government in December lordship.
Hmm.
So that instruction is awaited from the government.
There's also representation 39,22.
Where is your representation?
Annexure 5 lordship, page 23 lordship.
Annexure 5, page 33.
23,
23.
yes, lordship.
And this representation has been.
TLC lordship of Dorang district lordship has been forwarded her post lordship.
Hmm?
Her lordship, appointment lordship on compassion appointment. Her husband has been was work at Dorang district lordship, and TLC of the Dorang has been forwarded her post lordship, and job have approved the against the compassion appointment.
And lordship, this representation in terms of this honorable court's order dated 25/11/2022 has been forwarded to the government on 20/12/2022 lordship.
The widow lordship, she has been working from 2022 lordship after her getting the appointment lordship 200 kilometers away from the
Where is the earlier order of the court?
page 29 lordship. Page 29 lordship. And
Hmm.
that has been withdrawn lordship due to the further development of the representation lordship.
What developments? What
They have
developments
been
have
assured
taken
lordship,
place?
they have been assured lordship.
Huh?
They have been assured, given the assurance lordship,
Huh.
that they will do the action lordship. But till today lordship,
Under what provision is the transfer to be effected?
lordship, my learned friend may be allowed to submit lordship.
Actually, my lord, this four grade, my lord, employee, there is no provision, my lord, in transfer, my lord.
Then
But my lord, our my lord, the ground is otherwise, my lord. Because my lord, I filed writ petition, and on the basis of the writ petition, my lord, I was appointed on compassionate ground, my lord. But in the my lord, state level, my lord, my appointment is made, my lord, other district, my lord. So therefore, my lord, they have, my lord, chance, my lord, to transfer me, my lord, my native district, my lord. This is my ground, my lord. Normally, my lord, a compassionate appointment to be made, my lord, in a district, my lord, from where it is recommended by the
where were you recommended?
my lord, Dorong, my lord. Because
Dorong.
Dorong, my lord.
So you were posted in Dorong only?
Yes, my lord. But state level, my lord, committee, my lord, for unknown reason, my lord, I am appointed in the Kamrup district, my lord.
Of Kamrup district?
Yes, my lord.
Sometimes maybe because of that availability of the vacancy, lordship, sometimes in the same.
No, I am recommended against vacancy, my lord. Lordship is aware, without vacancy, there cannot be any recommendation. Only, my lord, there, my lord, job mela. I am victim of job mela, my lord. They made, my lord, all the appointment together. And my lord, one, my lord, mela was, my lord, called, my lord, the appointment was distributed, my lord. Yes, my lord, I am on not on that, my lord, on humanitarian ground, my lord, as there is a post, my lord, they may consider, my lord.
No, but humanitarian ground, you have already filed an application. Who is supposed to take a decision on this?
My lord, director, my lord.
That government will give the necessary.
Who in the government? Secretary?
Secretary. And that representation has been forwarded on 20th December, lordship.
All right, heard learned counsel for the parties. This writ petition is filed by the petitioner who is aggrieved by the non-consideration of a representation filed by her, ventilating her grievances for being transferred and appointed in a grade 4 post in Vidya Niketan ME School, Mongoldoy, Dorong. Stop. The petitioner is aggrieved by the fact that the petitioner was appointed on compassionate ground
Well.
and was recommended for appointment against a vacant post to the said Vidya Niketan ME School, Mongoldoy, Dorong. Stop. This recommended was duly accepted by the state level committee. However, while the appointment order was issued, she was placed in a grade 4 post in KTR Memorial ME School, Kamrup, within Brigade Metro. Stop. The petitioner otherwise has no difficulty in rendering her services in the school. However, from a place of residence, she has to travel almost 100 kilometers. Stop.
Distance is 100 kilometers.
Huh?
No, my lord, 200.
100 kilometers distance, as claimed by the petitioner.
Huh? So he says 100 plus 100, 100 to go and 100 to come back. This requires her to take arduous journey of 100 kilometers each way, putting her into great difficulty. Stop. Petitioner is a widow
My lord.
and has a daughter who's residing with her. Stop. Because of the distance in which she has to undertake, every day, it has caused immense hardship to her and to maintain her only daughter and the well-being of her only daughter, who's required to be left alone while she is rendering her duties. Stop. Under such circumstances, the petitioner had preferred a representation. Dated
Dated, my lord, page 23, my lord.
page
39.
23, dated 39, 309. Stop. since the representation was not adequately addressed, petitioner had approached this court by filing WPC 7537 of 2022 and this court by order dated 24/01/2023 had permitted the petition to be withdrawn as it is submitted as it is submitted by the petitioner that after filing the earlier writ petition, the petitioner was assured of being transferred to the school of her choice. Stop. However, after withdrawal of the writ petition, the representation remained pending and no specific orders have been passed. I agree the present writ petition has been filed. Kara. Mr. P. N. Sharma, Learned Standing Council, Elementary Education, was permitted to obtain instructions. The Standing Council, Elementary Education, was permitted to obtain instructions as per the last order. Stop. Today, Mr. P. N. Sharma, Learned Standing Council, Elementary Education, has placed before the court a communication from the Director of Elementary Education to the Secretary, Government of Assam, Department of School Education, forwarding the representation of the petitioner. Stop. On the basis of the instructions, it is submitted by Mr. Sharma that the representation is presently pending before the Secretary for disposal, and no further instructions have been received. Para. Having heard learned counsel for the parties and upon perusal of the pleadings on record, this court is of the considered view that the only prayer made in the writ petition is for disposal of the representation preferred by the writ petitioner seeking transfer to a grade 4 post in Vidyaniketan ME School, Mangoldoi, Torong, which is her home district, from her present place of posting, namely KTR Memorial ME School, Amsing, Jorabat, Kamrup Metro. Stop. The reasons seeking for the transfer are detailed in the representation. Stop. Under such circumstances, this court is of as such, this court this writ petition stands disposed of with a specific direction to the Secretary, Government of Assam, Department of School Education, to expeditiously consider and dispose of a representation dated 3009 2022 stated to have been filed before the director, and which representation has already been forwarded by the Director Elementary Education
On
to the Secretary, Department of School Education, Dispur, by communication dated 8th January 2023. Stop. The Secretary, while disposing of the representation, will consider the hardships faced by the petitioner and we will sympathetically consider the hardships faced by the petitioner, stated to have been faced by the petitioner. Stop. If upon necessary inquiries, if required to be made, the Secretary, if upon necessary inquiries to be made, if upon verification, it is found that the statements made by the petitioner in her representation are correct, then the Secretary will pass necessary orders to ameliorate the grievances of the petitioner, provided such a vacant post is available in the place where the petitioner seeks a transfer. Stop. In terms of the above, writ petition stands disposed of, the representation be disposed within a period of 30 days
What?
from the date of receipt of a certified copy of this order be furnished by the petitioner,
Along with my lord, kindly copy of the writ petition also. my lord.
along with a copy of the writ petition. Disposed.
Give to my lord.
Even money, 5. Yes. Hello, judgment. Yes.
Sorry.
Have you seen this order? Full bench order?
Yes, my lord.
So we'll dispose it off in terms of this order.
Full bench order, it's my lord.
That the petitioner will approach the appropriate forum, my lord, as per paragraph 23, my lord.
Yes.
Otherwise, my lord,
They are required to approach whom?
my lord, in paragraph 23 of the full bench judgment, my lord, it has already said that the remedy thereof would be to make a claim of for maintenance in the appropriate forum under the law and not a claim for a payment of the family pension by the state. And in paragraph number 21, it has been clarified that in case of Mohammedan also, the pension will be paid in terms of rule 143.
No, but this representation is to be directed to whom? To the respondent number 1,
So state my lord,
respondent 1.
1, my lord.
Yes, madam?
Yes, my lord, so respondent number 1.
Hmm.
They have a file representation before respondent 1, my lord.
That has not been disposed of.
They have not been disposed of. They have not considered their representation, but they kindly please see the page number 17. They their leave salary amount is disbursed to the account of respondent number 6.
Where is your representation?
Representation.
Representation was made by the daughter of the petitioner, my
Daughter
lord,
of
in
the
page
petitioner.
24, annexure 6.
But there is no seal of receipt, anything is there, lordship.
You file another one.
Along with the full bench judgment, my lord.
No, that is the instruction you are supposed to get and tell us whether this representation is pending or not. Hmm. Then we could have disposed it off.
It was submitted by the daughter, my lord.
Lordship may take it up at 2 o'clock, lordship, I shall obtain instruction and place before your lordship.
We will direct them to file another application.
Another
Lordship,
representation.
then
Okay? Heard learned counsel for the parties. This writ petition is filed by your part. Okay, check out. All right, we'll pass orders. Yes.
Good.
Second. Yes, disposed, yes.
lordship.
You are required to dispose of the representation within 30 days from
Lordship.
the date of receipt of a
Lordship.
certified copy. We are directing the authorities, you will file a representation, and in terms of the full bench judgment, they will consider your case and pass necessary orders. All right? Disposed.
I am for respondent number 5, my lord.
Mr. Hassan for respondent 5, Mr.
And
Dinesh
1 to
Bhattacharjee
time.
for
lordship, appear.
state respondent.
Obliged.
সেইটো কি দিব আৰু সেই অৰ্ডাৰৰ কপি এটা লৈ পেলাই সেইটো ফাইলটো নালাগে অলৰেডি আছে Yes.
May I please, your lordship?
Yes,
Already, lordship, petitioner has got relief, lordship.
you have got relief. Very nice.
Lordship, he has taken in training program. Also in payment, lordship, he has said as usual.
You have got your reliefs. You
Yes.
don't want to press it.
Hmm.
All right. Heard, learned counsel for the petitioner. It is submitted on instructions that the writ petitioner's grievances have been redressed by the respondents and therefore he does not wish to press the writ petition any further. Mr. Bodhakur appears for the
PHE department.
PHE department.
1 to
The writ petition accordingly stands dismissed as not pressed. Interim orders, if any, stands vacated.
May I please, your lordship? This matter relates to the suspension of the petitioner and more than about 6 months have elapsed.
Yes, instructions.
Lordship, here instruction I have received. Because the petitioner was arrested under POSCO Act, Lordship. And after his release, there is no any record in the office of the director that he has intimated that he has been released from the death. He is on bail. As a result, that review has not yet been done. And already the memorandum of charges and statement of allegation has been received. The departmental proceeding has been initiated on.
Under the rules, is there a requirement to intimate?
Even otherwise, I have intimated and I have also annexed the rules, your lordship, at page 28. Office memorandum framed by the government of Assam pertaining to Ajay Chaudhary judgment.
You have received your subsistence allowance. You have been receiving.
Ajay Chaudhary and Deepak Malik case, your lordship. If they don't make a periodic review within 6 months, then the suspension will automatically stand review.
Hmm?
If they do not make a
But Lordship, the petitioner has to inform the authority that he has been released on bail.
I have informed you.
And there is no record
that
as
is-
claimed by the director, Lordship. There is another communication where it is stated that in this connection, as per office record, no information of release on bail has been received by this office till that either from the petitioner or from the DO concerned. As mentioned by the petitioner in the petition, there is another communication. Lord.
What is the stage of the disciplinary proceedings?
Lordship.
What is the stage of the disciplinary proceedings?
This has been, so has been issued on 8 January, Lordship.
8
Okay.
January.
8 January,
Yesterday,
yesterday.
I have no instruction to that yet.
You have not received.
I have no
It was
instruction.
issued
8 January, yesterday
8
they might
January.
have given, so I did not get any instruction.
You get your instructions.
Lordship, otherwise my case is that as per Ajay Chaudhary judgment, so they have to
Even in
take a-
Ajay Chaudhary judgment, finally, when the charge sheet was issued, no order for reinstatement was ordered. It is only laid down the criteria.
Lordship, but within 6 months, what happened now? Only after filing of this case, they have now given this, your Lordship. Even Lordship has sought for instruction way back in the month of December, your Lordship. 2 occasions they have taken time, and yesterday they have issued this order, your Lordship. That does not validate their actions, which they failed to do. Ajay Chaudhary judgment, your Lordship knows that within 6 months there is a mandatory requirement, your Lordship. And I'll face it is not that I have any departmental anything, that I have done something within the department for which I have been.
No, but you're a school teacher
I'm a school teacher.
and the allegation is an allegation of an offense under
Actually, there is
POSCO
a
Act.
POCSO.
actually there is a love affair, your Lordship. The father lost the case. Now there is a criminal petition for quashing.
No,
The matter
whatever,
has been
whatever.
amicably
Whatever
settled, your Lordship.
is amicably settled.
Amicably settled means she was 17 years and something, your Lordship, which the petitioner was not aware. But the father of the this girl filed an FIR. Subsequently, he has understood that there is a love affair. The girl has in her 164 statement deposed that there is nothing as such in the FIR. And that also I have annexed to your lordship, I think.
In that case,
At
let
page
him
number
face the
22.
departmental proceeding.
But where is the order for review?
Yes.
Whether he is to be kept under suspension or not,
Lordship, that review has not yet been done, Lordship.
Then-
My instruction is because the petitioner has not informed that he has released on bail. Had he informed and had the department received the information about his release, then there would have been review.
What you will kindly take-
Because from the date of his release, 90 days it will come, Lordship, upon information. So that information has.
under
not
what
yet been-
provision?
Lordship,
Under what provision? Under what provision is he required to intimate?
Lordship, that provision is there.
What
I-
provision?
I'm having the need today. Because once he is arrested and he is detained, Lordship, he has to inform after.
By which order have you suspended him?
Lordship,
Lordship will get this order at page number 21.
21.
21.
So you have suspended him under 6(1)
Lordship,
when actually it is under 6(2). Hey, service manual.
Number 32.
So where, under what rules? It is under 6(1). So where under 6(1) is supposed to intimate?
It may go to the office memorandum framed by the government.
Hmm?
Office memorandum framed by the government themselves, your lordship. Incorporating the direction of the Honorable Supreme Court in Ajay Chaudhary case, your lordship. If within the period of 3 months, they did not serve any record or they did not serve any, then they have to review and extend the period of suspension. That has not been done till today, your lord.
Lordship may fix the matter. Next week, Lordship, I will place a judgment of this honorable court
Not
That-
A, there are
Yeah.
several judgments.
Lordship, lordship,
You'll have to place all,
lordship.
including division bench judgment. But your rules are silent.
Lost. Otherwise, six one.
Then six one also recently honorable single judges clarified.
But the rules are silent.
Lordship. That's why honorable single judge clarified it, Lordship. My
Okay.
brother will place it, Lordship.
Unless you clarify through your rules,
Lordship, Lordship.
how can the,
Lordship. But honorable court, after discussing
there
everything.
must be something to clarify.
Lordship, that part, that's because rule is silent, so honorable court clarified it, Lordship, from the date of intimate. My brother will place
I
that.
will, I will place
Yeah,
it.
Talking of Rafet Ali judgment.
I will place it.
Matter be listed again on 20,
Lordship,
sorry, 19th. 19 January,
lordship.
by which date the respondent will address the court as to why, as to whether a review has been, whether the period of suspension or further continuation of the petitioner under suspension has been reviewed.
Obliged.
Please, your lordship. Well, as agreed upon on the last date, well, this was a matter relating to after the division bench order and the single bench order, the Assam government to an OM overrid the judgment of the Guwahati High Court, and then they effected promotion. But today, as agreed, the last order of your lordship is very important. Mr. Majumdar will complete the instruction in respect of his communication. I had given a letter of the chief secretary. And my main ground was that the chief secretary's letter has added more chaos. And I'll show lordship how the chaos has happened. The chief secretary says that all promotion now should be as per rules. If it is under rules, it goes to my benefit. But the chief secretary today, I had a word with Mr. Nath in the morning. He said that the affidavit is not ready. It's
Which
okay.
not?
The senior government advocate.
Government advocate. Okay.
And he said, he also told me, knew that the case will be initiated. He said that Mr. Majumdar has some problem. Also, I have no grievance against Majumdar. On the earlier occasion also, he didn't come. Well, one thing I'd like to satisfy, if your lordship takes some my affidavits, which I filed just at the last time.
No, first give us an overview of
Yes,
the
yes.
matter.
Then I'll give, because this case, this letter of the chief secretary has got relevance, so I'll give an overview.
Where
So
is
what
that?
has happened?
You have enclosed that letter of the chief secretary.
Yes, Mullah, affidavit has been enclosed, the chief secretary's letter was enclosed. Mullah,
The-
this would have given a better picture of the entire case.
Affidavit filed by the petitioner.
Yes, my lord. Mullah, well, affidavit 3-1 at page 125. 3rd of January, 6th of December. Can I read it?
125.
Yes, Lord. This is a letter, the Lordship knows the roster affects the entire Assam government, 60 departments. So the chief secretary thought it possible that he will now issue instruction on 6th of December. You are aware,
We have not been able to locate. You're referring to which affidavit? Date?
we did. Malay, we had filed it on 3rd of January,
3rd of January.
2023. 24.
3rd of January.
May I please, Lord? In person to the last order, Malad,
Hmm.
we have already prepared an affidavit, Malad. I have sent it for vetting. Malad, possibly by today, I'll receive the affidavit. And today, I have little difficulty, Malad. I'm led by Mr. D. Majumdar, Malad. He is having some difficulty. He is not available today. I prefer taking up the matter day after tomorrow, Malad.
Well, I have some
In
objection.
in the meantime, Malad, possibly I'll get the affidavit. I'll file the affidavit by the time.
Because
Day after
our
tomorrow.
understanding was today I'll start the proceeding because there's an order of the division bench and on 11, Mr. Chaudhary will reply.
What is the
Yes.
order of the division bench?
Yes, my lord, if I may. My lord, I'll just give a short overview of the background of the case. My lord, what has happened in the year 2016, an OM was issued by the Assam government and a particular clause was included in it, clause 4, wherein the benefit of accelerated promotion and consequential seniority and merit was denied to the reserve, SC/ST. Immediately, Bhagwan Patter, he challenged the constitutional validity of the case on the ground that one
Constitutional validity of what?
of that clause,
Of that clause.
that it violated the office memorandum, that violated not only the constitutional provision of 16(4)(a), which gives the benefit of accelerated promotion and consequential, it's settled throughout the country. It also overrides the rules because the rules also envisage a cadre-based promotion at all levels. The division bench, the single bench in its order of 2022 specifically passed the detail order and striking down that clause and basically held that my right as an SC/ST does not get diluted by an office memorandum because when I go on merit in the higher post, I go as a member of the unreserved. And that is fortified by Supreme Court judgments of R.K. Sabharwal, that no one can take it. This is the law in India. So Assam government cannot have a new set of law to violate that right. Your Lordship, I'll take your Lordship to the single bench judgment at the constitutional validity of the subsequent OM was challenged in item number 14, the Radhe Assam Lanthasa case, which I'll start first. The item number 14.
No,
is the-
Mr. Das.
Yes.
The government wants to file some affidavit.
Oh, no,
Are
the
you
last-
proposing to start the argument without
No,
the
but
pleadings being
I will
completed?
take this because the government, to my understanding from 16, the government was always delaying the matter. They will file the affidavit on the 11th. I take the liberty, without the affidavit also, I can satisfy your Lordship. What is the position? For the simple reason, the government of Assam has already given their stand. So at least I want to start my case today.
No, I know you want to start. We are not stopping you from starting. What we want to know is, are we hearing the matter without even the pleadings being completed?
Pleadings are completed. This is an additional thing.
What affidavit do you want to file?
Yes, only one point.
Person to the last.
Pleadings is complete.
In fact, on last order, referring to the letter of the Chief Secretary, Chief Secretary Assam, some submissions have been made.
Hmm.
And to that, some clarification, we want to just bring it on record, by way of that.
What clarification have been issued?
An affidavit in the meantime, in item number 14, two affidavits have been filed on 3/1/2024.
Hmm.
Two affidavits have been filed.
No, you are filing an affidavit bringing some clarification.
In response to the affidavit filed on 3/1/2024,
Hmm.
and in response to the
Where is that affidavit 3/1/2024?
24 item number 14 they have filed,
14.
We have given an extra copy. We did.
Oh, what?
Yes. Where is that letter?
Yes, letter is of 6th of December at page 125,
Okay.
6th of December 23.
Yes.
Yes, you are aware, this is to all the secretaries. You are aware that as per the service rule, the Department Promotion Committee of the Selection Committee for Promotion of Officers and Staff of the Department and the Directorate's Commissioners are to be held before the calendar year so that promotion deserved by the officials and staff can be effected as soon as vacancies in different grade arises. This will also help in improving the administrative efficiency of the government as well as fulfilling the legitimate expectation of the government servant. In this regard, you are requested to arrange for all DPCs in the department, in the directorate or the commissionerate before 28 December 2023, except when there are legitimate difficulties due to orders of the Honorable High Court. There are DPC selection committee where the chief secretary is the chairman. I have reserved 3 days, 13, 14, 15, for holding DPCs for different departments. You are requested to submit your proposal immediately to the office of the undersigned for allocating suitable time for holding the DPC along with the other 3 days. For all those DPC selection committees where senior most secretaries of the department is the chairman of such DPC may be conducted before 28th of December 23, and the schedule of the meeting may be intimated to the office of the chief secretary in advance. Similarly, all the directorate commissionerate in your department may be directed to conduct DPCs for promotion of their staff before December 20th, 2023 and intimate the schedule for the meetings of the office of the secretary, chief secretary in advance. Your attention is further invited to the fact that there may be certain numbers of clear vacancies. Vacancies may also occur at different rank during 24 due to the retirement or superannuation of concerned officials or promotion of officers. Such vacancies may also be considered to the extent possible while holding DPCs for 2024, so that vacancies occurring during the retirement promotion may be filled up immediately as soon as such vacancy occur without the need to hold another DPC. You are requested to take necessary action in the matter. My affidavit was on the point that the chief secretary of Assam has used the word grades. Oblivious, he has used the word grades, that promotion has to be done. We know the anxiety of the government of Assam, because all cases, main case, all the roster is being stalled for 2016. And in spite of the division bench order and single bench order, the Assam government is defiantly going ahead with promotions on the basis of an alien concept. So your lordship will find the chief secretary curiously uses the word grades. He does not use the word cadre, because my entire case is hinging on the fact that the chief secretary by this letter is adding more confusion, because the Assam government, the present chief secretary is possibly not knowing that the chief secretary of the state of Assam in 2013 in the division bench has already given an affidavit to the effect that all promotions will be cadre wise. So is it a case that the chief secretaries at time, whenever there is a change in the hierarchy, they will keep on changing and they will violate judicial orders? This is a very serious case. Lordship will find.
No. What is this apprehension about grades and cadres?
This is the apprehension about grades and cadre is that my entire case is hinging that it has to be cadre promotions at all levels in terms of Supreme Court's judgment and the law of the country and the rules. The Assam government, since they did not comply with the division bench order and the single bench order, which says so, I had no other alternative but to inform the chief secretary from the time when the judgments went in my favor. The chief secretary kept silent, the secretaries kept silent, and the personnel department, which is supposed to be the nodal department, was also maintaining stock silence. For one reason, they did not want that the promotions be affected cadre-wise. Because if the promotion is affected cadre-wise, the reserve will get the benefit of accelerated promotion and seniority. They did not want that. A constitutional provision given to the reserve cannot be taken away by a rule. In fact, what has happened, the chief secretary has added now confusion for the simple reason. My ground is that the chief secretary in his affidavit now will have to clarify whether he is directing all the secretaries of the Department of Assam to go cadre-wise promotion or grade-wise. Because if it is not cadre-wise, then there is a violation of the Bhagwan Patra judgment and IV Guhai judgment. So and he is not giving an affidavit, if he not, then why is the chief secretary giving an affidavit in 13 before the division bench on a reservation case saying we will fully implement R.K. Sabharwal in letter and spirit? Because basically this...
No, what is the connotation for grade? What is it?
What has happened, if I may say, when we go in promotion, suppose I am an assistant engineer, I go to the cadre as a reserve at an earlier point of time because of roster promotion. When I go to the cadre, my seniority is fixed in that cadre in terms of my date of joining that cadre. That is the rules, the engineering rules, the civil service rules, all. Now, what has happened? The Assam government brought in an OM, rightly, wrongly, now I'll say wrongly because the judgments are in my favor, and wanted to downgrade us and deny the benefit of merit to us. As a result, my clients who were always on the top of list came down. It is at that time we moved the court saying that since you are denying the grade-wise promotion, we have lost our seniority, we have lost our promotional prospects, and we have our rights under the Constitution is being violated at the Supreme Court judgment. So the division bench in 13, this issue was always festering. So the division bench wanted an affidavit from the chief secretary at that point of time that you specify what is your stand on reservation, promotion. So that time the chief secretary gave an assurance before the division bench that we will go by the R.K. Sabharwal judgment. And the R.K. Sabharwal judgment talks about grades, not grade, it talks about cadre promotion, post base, and also it talks about that in the merit, when we go in the higher cadre, we don't go as a member of the reserve, we go as a member of the unreserved. So that was the issue. So now since the affidavit, the chief secretary will have to specify, because this letter of the chief secretary is adding more chaos. He is saying you go ahead with in different grades. So you'll have to specify whether that's a cadre.
But you said that the affidavit doesn't bring in any.
No, if they, because I can't stop the Assam government, they can give it on the 11th, but at least today can I not start my case? Because this was my argument on the last occasion. Your Lordship wanted that you start on the 9th and let them start on the 11th. In fact, I had a word with Mr. Chaudhary also. He is also ready. That on 11th, and the Assam government can also give their reply.
No. We understand your anxiety, but if you permit the affidavits or the pleadings to be filed, let it be filed. Let the
Then
affidavit be available on record.
Yes, Manab, the Lordship will clarify. The Chief Secretary's record, affidavit will also clarify the point, because now
we're not going to issue any orders. They want to file some affidavit.
Yes.
Whether it brings any clarification or not, we
then
don't.
It's okay, but then your Lordship let them file it. Let the matter be fixed day after tomorrow. Because on the ground of, because here I will.
I'll by that time I'll have.
No, show us the order of the division bench by which these matters have been directed to be listed before the court.
Yes. In fact, what has happened, we went before the division bench because the division bench was hearing the appeal of I.V. Gohain, and the division bench said that since the OM was not statutory at an executive order, the single judge can immediately take up the matter. So that was the order. And this was an order of 29/8/2023. Because now what has happened in all cadres, we are losing our seniority. That's our anxiety. Unless we finish the case, the government of Assam is going ahead and promoting. Your Lordship will know that the Chief Secretary's letters clearly says so. And we are being downgraded.
And what is the judgment in writ appeal 46?
Yes, in the sum and substance of the judgment was that they went on appeal, the respondent, the government of Assam never went on appeal. So the Bhagwan Patar's judgment is final for the government, but they won't comply with the judgment also. Now, the sum and substance of the division bench's order was that the main arguments of the respondent, that is the respondents out here, and the government supporting the respondents, that consequential seniority, which was given to you, has been withdrawn in view of subsequent OMs of the government of Assam, 16, 14. In two benches, the single bench and the division bench, that argument of the respondent was rejected on the ground that the OM giving benefit of consequential seniority flows from the Constitution, 85th Amendment. And the 85th Amendment of 2002 clearly gives the benefit of promotion and seniority to the members of the reserve. In fact, the central government OM, there is no such case, peculiar case anywhere in the country except here. Here, the Assam government says that we will give you promotion, but we will not give you seniority.
Where is that judgment?
Yes. The judgment. This is the judgment.
Is it not a part of the pleadings here somewhere?
No, this came up.
46.
We had filed an IA, but this came subsequently.
This is judgment in IV Das,
Yes,
IV,
IV Das Gohan.
IV Gohai Das Gupta. Okay. Yes, we have it here. That's it.
In fact, all the
Judgment
3
dated
points-
10/8/2023.
Yes, it talked about cadre-based promotion and it basically upheld the division bench orders. And in fact, what has happened at one paragraph, where it has clarified also what are para 45 also, it was clarified. Basically, sum and substance was that all promotion has to be cadre-wise, which was our contention. And 39 is the part which talks about cadre-wise promotion, para 31. In fact, one of the submission of an equality forum group, where my senior, Mr. Midal Chaudhary appeared, all the grounds of challenge to our rights were rejected. If I may read the paragraph.
Now against this, no further appeal.
No further. And state government has never gone. It was a bounden duty, judicial discipline, judicial administrative accountability calls for that when a judicial order is given, you don't go on appeal, but you take a view that we will not comply with the order. And this has been the scenario. As a result, Lordship can find, I can clearly show the chief secretary to the government, who is the head of the bureaucracy, doesn't know what he is talking in his letter, what he is talking, because his words are very important. He talks about grade. Malad, I can sufficiently vouch that the personnel department of the Assam government till now, 25 years, have not followed the cadre system. It is by providence that my case is now opening up the Pandora's box. We want a rule compliant government. We don't want a government who takes it side. And in fact, the Supreme Court has deprecated the practice of government taking side. This is a clear case where the government has taken side. In seniority matters, the government must be a neutral umpire. And 2 forums they have lost. Well, can anything now remain for them? But you don't deny us our promotion cadre-wise. And the ingenious method which they have now done, that since this judgment will also come in the 3rd judgment where I have now challenged the OM of 2023. If it comes, they also know the parameters. Before that, we will give promotion to the utmost and deprive all the petitioners. That's the logic. The facts has to be told. So what I want, let them file their affidavit day after tomorrow and I can start my.
All right.
Yes.
File it.
I'm fully prepared.
You can file it?
Yes, sir.
All right. It is submitted by Mr. D. Nath, senior government advocate, that an affidavit is required to be filed by the respondent department in response to some affidavit filed by them, to an additional affidavit filed by the petitioners in WPC number 363 of 2023.
Lordship will specify the letter, 6 December letter.
No, we said your additional affidavit.
Yes, the 6 December's letter. Communication.
Filed on, in response to the additional affidavit filed on 4th of January 2024 by the petitioners in WPC 363 of 2023. It is submitted that the affidavit will be filed within a day or 2. Stop. Learned councils are in agreement that the matter be listed again on 11th. On 11th. List accordingly, yes. You give the names, they will record it.
List accordingly. Well, your lordship is not recording that. No, the letter from the Panavatlati, I work on division bench. Well, your lordship is not recording the chief secretary's order before the division bench. Because the chief secretary has already given a division bench.
You produce it, we are
Yes.
now at the
Yes,
stage that
it
we are
was my
permitting
duty
them
as
to
a counsel.
file an affidavit.
Yes, yes.
And we'll examine the matter in
Exactly,
detail.
because it's my duty as a counsel
Yes,
to
yes.
inform the
You-
court
you
what
bring everything
information
on
they gave
record.
before the Guwahati High Court division
You
bench.
bring everything on record.
Yes, sir. Obliged.
Technique, I don't know.
May it be the lordship. Yeah, I'm praying for some time to file my affidavit. I have received the instruction.
Mr. N.J. Kharonia, Learned Standing Council, secondary,
Elementary, my lord.
elementary education submits that an affidavit is required to be filed. He prays for further time. Mr. A. Dekka, Learned Counsel to the petitioner, does not object. List after 3 weeks.
The date may be fixed with after.
Let him file first.
The affidavit from the finance department is also required because here also the.
Other
petitioner-
respondents are also permitted to file their affidavit if so advised.
After 3 weeks, any date, Lord. Otherwise, in the month of February, Lord, any date,
19th
19th of February.
February.
Deeply obliged. Thank you. May I, Lord? Lordship, in this case, Lordship, the petitioner has not been given his Lordship salary, Lordship. Therefore, the petitioner filed this petition after.
Salary.
Lordship, regular salary, Lordship, monthly salary. Then Lordship, after filing this petition, Lordship, after receiving the Lordship notice, the respondent number 4 granted Lordship April to December, November, the salary of the month of from April to November. And the remaining has not been till
November
November 2022, Lord.
22.
And he has filed an affidavit, Lordship. And in this affidavit, his stand is that, Lordship, the petitioner was not regularized, therefore he has not given, Lordship, the salary, Lordship. Whereas, Lordship, after receiving the Lordship notice from the school, Lordship, he released the salary from April to December, Lordship. And this after remaining has not been, Lordship, released, Lordship. Still, he has not given the current salary, Lordship. Lordship, I have also filed a reply of his affidavit, Lordship, and I have taken.
Yes.
Lordship, I have stated in my paragraph, page 148, Lordship.
Who's for the respondent? Which department is it? PNRD.
PNRD, Lordship. From the last collection, Lordship, they were not available, Lordship. When petitioner is suffering, Lordship, he is not getting his regular salary, current salary also. And what happened, Lordship, though the respondent number 4 released the salary, Lordship, from April to December, Lordship. In this case, Lordship, the respondent, Lordship, reduced his grade pay and Lordship, house and Lordship. Whereas in fact, he has no authority to reduce the salary of the petitioner, Lord.
Other than this matter, my colleague Ripta will be appearing. Kindly have it passed over the timing. Madam.
Your affidavits are on record. Who's the counsel appearing?
Ripta Datta.
Please call him.
He's on his legs in court number 2.
Call him, call him. Yes, time being. We'll take it up after a while. Yes.
On the last occasion, my lord, the question was raised by my lord, train that mine was a technical resignation. And lordship wanted to inquire from him as to what it means. My lord, technical resignation as per the pension rules, my lord, is a resignation when the continuity of service is being given in the next employment.
He had resigned from
Tezpur University.
Tezpur University. Before
And
joining.
I am seeking pension from them, my lord.
Huh.
And curiously enough, my lord, the provident fund portion has been given to me by the Tezpur University,
You are referring to some notification.
my lord. Notification was in fact annexed by this.
Yes, Mr. Gogoi.
Lordship.
In their affidavit also, they have said, it is clear from that, my lord, that when it is a in case of a body, autonomous body, where the pension scheme is an operation, is entitled to pension from that department. And I have categorically stated immediately after my resignation from the Tezpur University that I will opt for pension from your department, from the university, and for the rest of the service, my lord, in the other organization, that will be, I treat it as new. I don't want to continuity of service. And in view of that also, they are bound to pay me pension. And they have already, pension is not only pension, it is gratuity and provident fund. Provident fund portion has already been given to me by them. So if one portion is given without any murmur, why the other portion is not given to me? It is being held up.
Yes, what do they say in their affidavit?
They have not said because they said, since I have resigned from them and have taken other service in the Near East, I am to get pension from them. But Near East, I have stated in that letter also that I am seeking pension from you, that Near East does not have pension scheme. So I'm not getting regular pension and they have CPF scheme.
No, under what provision are you claiming the pension from Tezpur University?
Since I have resigned, my lord, clause 5, rule 5.
CCR pension.
CCR. Pension rules.
Yes.
Claim to pension or family pension. Rule 5.
Yes.
Any claim to pension or family pension shall be regulated by the provisions of these rules in force at the time when a government servant retires or is retired or discharged or is allowed to resign from the service or dies, as the case may be. Since I have resigned from there, my lord, I am entitled to. And they have said, my lord, casually, that
You are entitled, according to them, you are entitled to pro rata.
yes, I am entitled to pro rata. I will get that only, and they have calculated it also. Tezpur University. I think I have this. I have submitted two orders from the department, my lord, of the Tajpur University. Where they have calculated my pro rata pension.
Yes.
They
Mr.
have
Gogoi,
calculated it, my lord. Only they are not withdrawing it, no, releasing it, my lord.
yes, Mr. Gogoi.
Lordship, he is entitled for pro rata pension, Lordship. And that pro rata pension, we have to, Lordship, hand over to the nearest, Lordship.
You have to?
We have to deliver to the nearest, Lordship. Nearest will provide him, Lordship.
Why? They don't have a scheme.
Lordship, they have done, so that he is entitled for pro rata pension, Lordship.
Uh,
So Lordship may, first Lordship may kindly come to technical resignation part, Lordship. What do you mean by technical resignation part? It's not a resignation. Petitioner projected the case is that he is resigned from service, Lordship. It is not a resignation, Lordship, as per rule
he had
5
gone
of the
on,
pension.
he had
Lordship.
gone on deputation. No. Did
Lordship,
you go on deputation?
Lordship.
No.
He is on lien, Lordship.
He was
Ah,
on, he was on lien
He is on lien,
for 2
Lordship.
years, and thereafter, when the lien was not extended, then resigned. So my service with Tajpur University has
He is
ceased
on lien, Lordship.
when I resigned from them.
Yes.
This office memoranda, although it's a office memoranda 22, Lordship, but concept of the technical resignation, we can, Lordship, bring it from it, Lordship.
Please read.
Lordship. Technical resignation and lien, Lordship. Office memoranda 24th November 2022, issued by Ministry of Personnel, Public Grievances, Pension Department, and Personal Training, Government of India, Lordship. 2.1, Lordship. As per the Ministry of Finance, OM dated so and so, the resignation is treated as a technical formality where a government servant has applied for proportional for a post in the same or some other department and on selection required to resign the previous post for administrative reasons, Lordship. The resignations will be treated as technical resignation if these conditions are met, even if the government servant has not mentioned the word technical while submitting his resignation. The benefit of past service, if otherwise admissible under rule, may be given to such cases. Resignation in other cases, including where competent authority has not allowed the government servant to forward the application to proportional, will not be treated as a technical resignation, and benefit of past service will not be admissible, Lordship. Here, Lordship, it's a technical resignation, Lordship. He is going on lien, Lordship. When lien was not extended, Lordship, he opted to tender his technical resignation, Lordship. Also, no questions of benefit or resignation being treated as a technical resignation arises in case of being from post held on ad hoc basis, Lordship. The benefit is also admissible to the government servant who have applied before joining that part is other part, Lordship. Here, Lordship, carry forward of the leave benefits when technical resignation is there, Lordship. Carry forward of a LTC, Lordship, next page, Lordship. And pay protection and eligibility of past services for knocking the minimum period of grant of annual increment, Lordship. And GPF transfer, seniority also transfer, Lordship. Applicability of pension scheme, Lordship. In the cases where government servants were originally joined the government service prior to the 1/1/2004, apply for the post of the same or other department, and on the selection, they are asked to tender technical resignation. The past service are counted towards pension if the post is in pensionable department. As per TCS pension rules, Lordship. And if it is after 2004, then new pension scheme will come, Lordship. This is the benefit of the technical resignation, Lordship. Here, petitioners goes on, Lordship, technical resignation, Lordship.
Two point seven says there will be pension scheme will be applicable.
Lordship, pension scheme will be applicable, Lordship. 2.7 says, in cases where government servant, we also not denied, Lordship, will entitled for pro rata pension, Lordship. Here, what is says 2.7 Lordship? 2 says that in cases where government servant who had originally joined government service prior to 1/1/2004 apply for post in the same or other department and on selection, they are asked to tender technical resignation. The past service are counted towards pension if the new post, Lordship, is in a pensionable establishment in terms of rule so and so, Lordship.
Pensionable establishment.
Lordship.
Here
Here,
is not pensionable establishment.
here, Lordship, the autonomous body nearest Lordship, the CPF provision is there. When CPF provision is there, there is a office memorandum issued by the Lordship Ministry of Personnel and Training Department. It is all, we have annexed here with Lordship may kindly peruse it in our affidavit, Lordship. What is the consequences, Lordship?
Yes, what?
Lordship. Lordship, we have filed affidavit, Lordship.
Mhm.
My lord may kindly come to page 59, Lordship. It's annexer R11, Lordship.
50?
Page 59, affidavit filed by the Lordship. Register of Tesco University, Lordship.
Yes. Yes.
Mobility of personnel between central government department and autonomous bodies counting of service for pension, Lordship. Nearest is the autonomous body, Lordship. Originally is a Tezpur Central University, Lordship, where pension scheme is there. So Lord, my lord may kindly come directly to Lordship, page 60, Lordship.
Mm. Yes, B.
Lordship, B.
B1.
Lordship, I mean, I can read it, Lordship.
Yes, please B.
Lordship. Autonomous body where a pension scheme is not in operation, Lordship. A permanent central government employee born on pensionable establishment on absorption under such autonomous body will be eligible for pro rata retirement benefit in accordance with the provisions of Ministry's Finance OM dated so and so, Lordship. As amended from time to time, in case of quasi-permanent or temporary employee, the terminal gratuity as may be admissible under the rule would be actually payable to the individual on the date when pro rata retirement benefit on permanent employee become payable. However, in case of absorption of the government employee with CPF benefits in such a autonomous organization, the amount of his subscription and the government contribution, if any, together with interest thereon shall be transferred to his new provident fund account with the consent of the body, Lordship.
Yes, so here
he is under the CPF
he is,
scheme.
he is entitled
Lord.
to pro rata retirement benefits.
Lordship.
You have given me.
He is. We are not giving. He is entitled to pro rata pension, Lordship. It is not a dispute, Lordship. Today, our affidavit also we have said that he is entitled to pro rata pension. Even Lordship, earlier he is a Dhanbad, Lordship. Lordship may remember it. Dhanbad, he is more than Lordship than Tezpur University. Dhanbad, he has more than Lordship 20 years, Lordship. The service who is rendered in the Dhanbad, Lordship, Dhanbad has sent to the amount of the pro rata pension to us, Lordship. Here, Lordship, only less than 6 years service in our. If his claim is that he is resigned from the Tezpur University, he is entitled for pension. He can claim pension for Dhanbad also, Lordship. He will entitle Lordship to.
No, he's not claiming for Dhanbad, he's claiming for Tezpur. Now he.
That's why I am saying, Lordship. He is
Ah.
also in the Dhanbad technical resignation. Dhanbad has sent to the proportionate pension to us, quota pension amount to us, and we also send it to the nearest Lordship. And next two Lordship. Roman 2 Lordship, Roman 2.
Hmm.
An employee of an autonomous body on permanent absorption under the central government, it's not applicable. Otherwise, Lordship, B1 is applicable, Lordship.
Yes, B1 is applicable.
B1 is applicable. He is entitled to pro rata pension, Lordship. There is no dispute, Lordship, regarding pro rata pension.
According to you, this will be available from nearest.
Nearest, Lordship, we will, Lordship, hand over the amount, Lordship. As like the Lordship, it was by the Dhanbad Lordship. If Lordship permit, I can place my affidavit, Lordship.
Where is the annexure 14 in the writ petition? Annexure 14.
Annexure 14, Lordship, page 35, Lordship.
Hmm.
Page 35 of the writ petition, Lordship.
Mr. Tolia, I think on the basis of the OM which he has shown at page number 60, B1.
No, my,
That-
my,
You are aggrieved by the letter at annexure 14.
yes. But in my humble submission, I am covered by of that OM, covered by rule A, not B.
A.
A. Because I have opted for them, for that. Where a central government employee born on pensionable establishment is allowed to be absorbed in an autonomous body, the service rendered by him under the government shall be allowed to be counted towards pension under the autonomous body, irrespective of whether the employee was temporary or permanent. Pensionary benefits will, however, accrue only if the temporary service is allowed to be is followed by confirmation. If he retires as a temporary employee in the, but I was confirmed in that period, Tezpur University.
See,
And
you are referring this to your services from Dhanbad to Tezpur.
no, previously I was in central government, purely central government. Then I opted for Dhanbad. Dhanbad is like Tezpur University. It is a autonomous body under the central government.
No, now, if you say you are covered under clause A,
Yeah,
for which part of your claim or which part of your period of service? From
no,
Tezpur,
it is continuous service, because
no,
I'm-
kindly see clause A1.
yes,
A1 says that
services
or-
rendered by him under the government shall be allowed to be counted.
so firstly, if you look into A, it is autonomous body where pension
Where
scheme is in
Lordship,
operation.
pension scheme is in operation, Lordship.
Is in operation. So if it is nearest, according to him, it is not in operation.
No, Tezpur it is operation.
No. Autonomous body, this is with regard to mobility from central government to autonomous bodies.
Yes.
So from central government, you came to
Dhanbad.
Dhanbad. From Dhanbad to Tezpur.
Tezpur. Dhanbad and Tezpur both are autonomous bodies under the central government. I get continuity upon service, below.
No, but thereafter,
Then when I when I came out from the,
Now, your claim is that since you have submitted technical resignation in Tezpur, it is Tezpur who will have to pay.
yes, my lord, because I have given a letter to them also. That Annexure 9, my lord. Dated 17/10/2008.
Mr. Gogoi, what do you say? Because see, what Mr. Cholia is trying to project is, he was in central government. From there, he moved to Dhanbad. From there, he moved to Tezpur.
Yes, I get continuous service for the whole
Now,
2 years.
in Tezpur, from
Resign.
there, he goes on, he gets a lien and goes to Neris, but he submits his resignation in Tezpur.
It's not a resignation, it's a technical resignation.
Whatever.
He's on the lien lordship.
No.
He's on the lien lordship.
He doesn't get the extension of the lien.
Does not get the extension of the lien,
Hmm.
so he's technically resigned lordship.
Right.
Resign.
So
It is not a resignation lordship.
whatever it is,
Lordship.
so under such circumstances, he's after he submits that technical resignation, he's
Lordship.
no longer deemed to be an employee of Tezpur.
But lordship, the service benefit lordship,
Hmm.
it will transfer continuation of the debt period will be lordship adjusted to the nearest lordship.
For that, my lord, I will refer your lordship
It
to page
adjusts
27.
because
of my
technical, if a person is technically
In
resigned,
in terms of your OM,
lordship,
uh,
if
he
lordship,
appears to be falling under category A.
if lordship, he is permanently resigned from the particular, resigned from the Tezpur University, not absorbed in any other lordship department, then A will be applicable. His case is applicable in the BS because lordship, from the Tezpur University, he is on lien to the lordship to nearest as a register of the nearest lordship. When we are not extended the lien period, he technically resigned lordship, and the continuation of the debt period will go to the nearest lordship.
So that would be applicable had he been a central government employee coming directly to Nerist.
Lordship,
Yes,
here lordship, he from that autonomous body also he went there lordship. We are,
No, I think clause B, you see, Tezpur, are you saying that Tezpur is an autonomous body?
Tezpur University
Yes.
Central Government Institute lordship.
Uh,
It's a central government institute lordship. It is all the rules regulations framed by the central government are applicable. We are not a autonomous lordship.
you are not autonomous.
Lordship,
So therefore,
lordship,
coming to Tezpur,
lordship. Dhanbad Mines Institute is an autonomous institute as per the petitioner lordship, but Tezpur University, Central University is not an autonomous institute lordship. It is lordship is a part of the central government, Ministry of Human Resource Department lordship. Not only Tezpur University, all the central universities of India lordship.
no, they are,
They are the central government lordship, institute lordship. It's not an autonomous body lordship.
I have made specific statement at paragraph 3. It is an autonomous body created by an act of the parliament. It is fully financed and governed by the Ministry of Human Resources of the Government of India. As an autonomous body, all central government rules are also applicable. And lordship will see paragraph
okay. Yes,
paragraph 8. 8, no?
paragraph 8 of,
No, I'm sorry.
huh? Okay, we
And-
pass orders then.
Well, lordship, my lord may
Paragraph
kindly.
13, paragraph
Well,
13 also,
well, lordship,
in my appeal,
in the
at page 34.
Hmm.
In this regard, the position of my claim as on date is as under. General Provident Fund is already been settled and paid to me in 2009
By whom?
by Tezpur University.
Ah.
And only these two claims are leave encashment and pension and gratuity. So
Very well. We'll pass orders.
Even my lord may kindly peruse lordship OM for a moment lordship 59 page 59 lordship. A Roman 1 and lordship sub paragraph. What sub paragraph says lordship? Sub paragraph. Then also prorata pension lordship. And lordship in our affidavit I am relying paragraph 4, 7, 8, 9 and 10.
Yes, yes. Yes, OM, which paragraph?
OM also lordship in the A sub paragraph also lordship.
Hmm.
It's about says that prorata pension. Just I am mentioning lordship. Otherwise also lordship is entitled, he is covered by the B lordship.
No, there is no dispute. It is pro rata pension.
Lordship.
Question is, who is going to pay?
Lordship,
Yes.
it's
That
by
is
the
the issue.
lordship. We have to transfer it to the lordship, the nearest
Because according to you, you are not an autonomous.
lordship. Even my lord make
But you're the university.
lordship.
How can you say you are not an autonomous
Lordship,
body?
it says central government institute lordship.
How? It is not a, it is,
Lo-
it follows central government rules, regulations,
Otherwise,
etc.
also lordship, if the case is that lordship, he is permanently retired from the Tezpur University, then lordship picture is other defined way lordship. He is not permanently retired or permanently resigned from the Tezpur University. He is on technical, he is on lien to accommodate in the lordship, nearest lordship. If nearest part is not there, then view is other way lordship. He is on, why he is come to nearest? In nearest for the further employment lordship. And when the Tezpur University lordship did not consider the extension of the lien, he is technically resigned lordship. The issue is totally defined. And lordship, I am relying paragraph 4, 7, 8, 9 and 11 of our affidavit lord. My lord may kindly mark it.
Okay.
your lordship may see page 27 of mine, where I have given specifically stated
If he
They
is
have
not in the nearest, then lordship
they
thing
did
is
not say
otherwise.
anything about this letter. That was in 2008, immediately after my resignation in 2007.
Regarding prorata pension and technical resignation lordship, my lord, may one judgment of the Honorable Delhi High Court is there. Lordship may kindly peruse it also while passing the order. Beto.
Hard disposed. Yes. We will pass the order.
Delhi High Court.
Yes, which judgment?
Lordship, I have just referred. It says about the OM lordship. Regarding that part, lordship, we in the Sami's book also it is in the lordship page 459 in the pension compilation lordship.
We'll go it. We'll go through it.
459 lordship, page 459.
459.
459
All
lordship.
right, okay.
And that OM was discussed by the Honorable Delhi High Court lordship, division bench of the Honorable Delhi High Court in that particular judgment lordship. 459 lordship.
Yes.
459 lordship.
Okay.
Always lordship.
The matter pertaining to suspension or the subsequent effect thereto, lordship, can you see the order dated 6/12/2023 passed by this Honorable Court?
6,
12.
12.
Now, lordship, the file has been called for in respect of verifying the part of review. Now, Friday, my lord, the file has been put before this honorable court, another bench.
Huh?
On Friday, the matter was listed. The file was placed, and we have been also directed to pay the file and make comment on that.
Which Friday?
Last Friday, my lord.
Last Friday. Okay. Then
My lord, we have gone through the file as per the direction, and we have found that no such review has been done.
How the petitioner can make submission like that?
My lord,
The record is here, my lord. Kindly see the
Lordship,
record.
let me make my submission, my lord. Kindly see
Malad-
the file.
My lord, kindly see.
what is the stage of where is your suspension order?
Suspension order
Page
is
88.
under challenge at page number, kindly see at
88.
20?
80,
18?
88.
80.
It's a 7. 88. double eight.
88.
Clear. The record to different. Very good.
Six one A.
Yes.
Yes, sir. 6 1.
Now, my lord, subsequent extension was done 24/5/2020.
Where is that?
My lord, this is the part of file, my lord.
Part of the record.
And there the extension was done.
Service. Assam service.
So record. Extension I believe is extension record kori ase.
Now, lordship, kindly have a look to page 144.
We'll look into it. Page number.
My lord, 144.
So let me refer to the record, my lord. It's our record.
I'm
I'll
referring
refer.
about record, my lord.
My lord, Lordship may kindly see, my lord, flag B1 and B2. B1 is the show cause notice. B2 is the suspension order. 9/2/2023.
Okay.
Then kindly, my lord, note sheet. Lordship may kindly take the note sheet, my lord. The green note sheet. Page 37, my lord. Page 37 onwards. It is page 37 below, my lord.
Yes.
37 below, my lord. They have initiated the process for review, my lord. And it goes to 38 and 39 also.
So when were you suspended?
On 9/2/23, my lord.
9/2.
9/2. Flag B2.
9/2/23.
9/2/23. On 28/4, my lord, April, it was processed, my lord.
Is there no order passed after?
Yes, order was passed, my lord.
Where is that order?
Order is passed.
Where is that order? After review?
Flag 4. But kindly see flag 4, my lord.
4.
24/8. Wait, 24/5. 24/5. 24/5, my lord. With effect from 9/5, it has been done. Flag 4. I go to do it before that, recorded record.
Yes. Then.
Well, in the meantime, the repetition was filed on 16/8/23. Lordship has directed us to bring the record. On 24/8, the record has been given to us. The Lordship will have a letter on the top of the cover. On 22nd of August, record has been transmitted to us. On telephonic instruction, my telephonic instruction is that the review is being done regularly. But kindly have a look at the case of the petitioner. What is the projected case of the petitioner in the writ petition? Kindly see para 14 and 15 of the writ petition. What they have projected in the writ petition actually. This is not under challenge. The review has not been done. This is not their challenge. Can you see para 14 and 15? What they have said? They have said that the respondent number 2, respondent number 3 has no authority to issue the suspension order. They are challenging our authority. Para 14, page 16, may kindly see. The petitioner again begs to state that the procedure adopted by the respondent number 3 while issuing show cause notice dated 9/2/23 has no basis at all, since the law applicable under the Assam Services Discipline and Appeal Rules 1964 cease to operate when a person is allowed to operate as a managing director of a particular institution. Be it stated here that the present petitioner, while performing the duty as managing director of the respondent number 2, comes under the domain of Companies Act 2013, and if any illegality has been committed while holding the charge, the statutory forum available under the said statute is amenable to attend such grievances, if so raised. Therefore, from this point of view, the activities standard by the respondent number 3 are without jurisdiction, and as such, it demands further interference of this honorable court. Then kindly see next page. Next para, that the petitioner further begs to state that the show cause notice and the suspension order dated 9/2/23 issued by the respondent number 3 is also under challenge before this honorable court, since prior to initiation of such proceeding, the approval of the appointing authority, that is the Honorable Governor of Assam, is invariably required. But from the bare perusal of the show cause notice dated 9/2/23, it is discernible that the respondent number 3 is not the appointing authority, and no necessary approval has been obtained from the Honorable Governor of Assam while initiating the departmental proceeding against the present petitioner. So these are the grounds of challenge, and accordingly he has prayed for, page 18, kindly see. Prayer is, a writ in the nature of certiorari may be issued to set aside the show cause notice, being notification number so and so dated 9/2/23 issued by the respondent number 3, thereby alleging the petitioner of being involved in the illegal appointment of the contractual employees in the office of the respondent number 2. Next is, my lord, certiorari to set aside the impugned suspension order number so and so dated 9/2/2023 issued by the respondent number 3, thereby placing the petitioner
Issued in
under
the name of the
suspension.
governor.
My lord,
It's issued in the name of the governor.
my lord, kindly see, my lord, the rule is that, my lord, that the matter must be brought to the notice of the governor. It cannot be.
It is
as an
issued in
empty-
the name of the governor. Are you saying that this is falsely
My lord, no, my lord, I'm not saying.
uh,
Lordship, that whether this,
indicated?
my lord, whether this matter was brought to the notice of the honorable governor, that lord, that reflects the file. Whether approval was given by the honorable governor, that also, my lord, to be approved by the file, my lord. But I will counter, my lord, let him complete, my lord.
Well, the challenge made in the writ petition is that the respondent number 3 is not the appropriate authority. He has no power to issue the suspension order. And the
Vis-a-vis the powers of the governor.
power of the governor, and my lord, the challenge exactly that is the challenge in the writ petition. In fact, there is no challenge that the suspension has not been extended. Nothing, no pleading is there. My lord, I have my lord placed the record there. Lordship will find at note sheet number 38, my lord, 38, 39. The approval of the honorable CM is there. He is the competent authority. We have said, my lord, with the approval of the competent authority, suspension order has been issued.
If it is the CM, then why have you issued in the name of the governor?
All things are issued in the name of the governor, my lord. It is in the name of the governor, but the competent authority, highest authority, has approved it. With the approval of the highest authority, it has been done.
If it is for the governor, then the governor's approval must be obtained.
No, it is in the name of the governor, my lord.
Then
But the challenge of the petitioner, as I have indicated, my lord, that she was in a company because therefore the 2013 Act, Companies Act, that will prevail, and the respondent number 3 has no authority. It is completely misconceived because she is an SES officer, my lord. Personnel department is the cadre controlling authority of an SES officer. She cannot claim that the personnel department has no authority over her. And the suspension order has been challenged. Against the suspension order, appeal lies, Lord. The petitioner has not filed any appeal.
against the suspension order.
Yes, Lord. Under Rule 14, Lord.
Okay. Anyway, then. Yes.
Let me first make the position clear in respect of file, my lord. Then I will come.
Respect of?
File, my lord, the file placed by the department. So the position is such that, my lord, kindly see the note sheet, my lord, 37.
Yes, we've seen it, yes.
Note sheet.
Ah.
37 banner note sheet says by note sheet registration given for conveying review of the suspension order. There was only a note sheet reflect about conveying the review meeting. In 8/5, my lord, 2023, a draft was prepared. Now thereafter, my lord, on 13/5/2023, the suspension period for extension was placed to the CS and thereafter it was forwarded to honorable CM. Now, lordship, kindly see 144, the review meeting, whether it has been held or not, it is totally, my lord, uncertain because 144 page, there is no any date, my lord. It is just a empty formality that they have conveyed. Otherwise also, my lord, the review has to be done within 90. Lordship, kindly have a look for a moment, file, my lord.
Under?
File, my lord.
File. Okay.
Records, my lord.
Yes.
Records, lordship, page 144. They are relying upon this, my lord, decision of the review committee.
Yes.
Lordship, kindly see undated. Nobody knows when this decision was adopted. And there is no any reflection about this decision in the note sheet, my lord.
Yes.
Now, kindly see, lordship, note sheet that followed by this decision, it is nowhere stated in the note sheet that on so and so date, a review committee adopted a decision. Page 37, 38, 39. Nowhere reflect. Otherwise, also, lordship, we see, even on 8/5/2020, a draft was only prepared. That means 90 days on that day over. Page 37. 38, sorry, page 38, 8/5/2023 note sheet. Reflect draft was prepared. That means on that day, 90 days was over. It implies that till date, no review committee adopted any decision for extension. It across 90 days.
There is a reference.
My lord, 37 say, hide note sheet suggestion given for conveying review of the suspension order.
Then
And page
38
38 says a draft was prepared.
No, final copy.
No,
final
no,
copy
38.
Draft means, my lord, minutes of the draft. Bharat.
No, it is signed. Next page, lordship will say, see, it is
Let
signed.
me complete, my lord. I may be wrong. That
No,
will-
no, no,
That
no,
can
no,
be
you are-
verified
you
by
are-
the lordship is there.
No, I have to indicate the thing. Malad. It is signed. I have the copy.
8/5, there is a note sheet endorsement that meeting was already held to review.
That's why, my lord, meeting when held, nobody knows. There is no any reflection when this decision was adopted. That must be the part of, my lord, note sheet that on so and so, a decision was adopted for review of so and so, and accordingly draft has to be prepared. And if we see the, my lord, notes that minutes of the review committee, it's undated, my lord. It's just signed, my lord. Might be it is filled up afterward, my lord. Nobody knows.
Then these allegations, you have to bring it on record.
My lord, because file are there, my lord. We have just gone through on Friday, my lord. It is not within our position.
If you
Anyway,
want
my
to
lord,
bring
I'm
it-
coming to the second
If you
point.
want to bring it on record, you bring it on record.
I'm coming to second point, my lord.
Ah.
Thereafter, my lord, consecutively 3 review was done. Kindly see 3 reviews, my lord. Now, they want to take a plea that by 16/8/2023, the file was called for by this honorable court. But, my lord, 9/2/2022, 23 order, it ought to be extended on 9/8/2023. That was not done. Prior to that, the file was in their custody. These are the 3 orders, my lord. And afterward, my lord, there is no any sitting in respect of, my lord, review of the extension of the suspension order. Who stopped them to open a parallel file? Who stopped them to call for the file, my lord? It is not the file which has been lying before this honorable. The file was in their custody, my lord. And where is their bar, my lord, to review the rest part of that extension order? There are 3 extensions done, my lord, on 24/5/2023 that I have put before lordship kind attention.
Yes.
Now, the next extension was done on 14/8/2023 prior to placing of file.
Hmm.
And last extension was done 22/11/2023.
Hmm.
These 2 extensions, my lord, without any review. Now, lordship, I am coming to
You bring it on record. If
My
you
lord.
want to make these, according to you, these are not reflected in the records.
My lord. My lord,
So-
because my lord, file has been placed on Friday, my lord. The file in their custody. That's why my lord, file has been called by this honorable court to verify whether the review has been done or not. Now it's very, from the page it shows that.
It's not here. It's not here. Is there any other file?
This file was given to us on 2022/8. In the other things are in the other part file, in the other part file.
So where is that other part file?
Well, that copy email I have received, Malad, that I can place it. The original I can.
Lordship,
Well, in fact,
Lordship-
Malad, this is not the
Lordship, may I
the
point
case
out
of the
only one thing,
petitioner.
my lord? Lordship, may I point out
This
only
is-
one thing, very important, my lord. The second extension was done on 14/8/2023.
Hmm.
And they have placed this file to the learned council on 22/8. That means prior to that, the file was there. Very clear, my lord.
You are making allegations that these are doctored. These are interpolated. You are hinting at that.
No, my lord. What I'm saying, my lord, extension is not followed by review committee's decision. my lord.
That's right. So ordinarily, when an order of extension, that too issued in the name of the governor,
My lord.
is issued. These are all issued in the name of the governor.
My lord.
So there has to be proper material in the records.
My lord,
So
only one point, my lord, subject to your lordship. Lordship, they are saying by order and in the name of the governor. That means the questions crop up, my lord, that by order, that means there must be direction from the honorable governor, which they have to justify before this honorable court whether the honorable governor has approved this extension or not, or the whether matter was brought to the notice of the honorable governor or not. That reflects from the file. It is their duty to justify before this honorable court. We are saying, my lord, that by in the name of governor, if somebody wants to take a plea, my lord, then it must be brought to the notice of the governor. It's a substantial part of requirement, my lord. They cannot just use the name. Otherwise, he may that honorable governor may not know. Lordship, kindly see the file whether any exercise has been contemplated or not.
Hmm.
Lordship, kindly see the extension which has been done subsequently. The extension, first extension 28/4/2020. Let us take for a moment that it has been reviewed.
Mr. Counsel, these arguments you are making are not supported by pleadings. We'll have to confront the respondents with these arguments. How will they respond? How do we pass orders on your submission?
My lord, Lordship,
If you want to file an affidavit, you file it, bring it on record.
my lord, we'll bring it on record. There is no problem, my lord. But kindly see that this honorable court, on the basis of the last extension order, directed them to produce the file to justify whether this suspension extension is justified or not in accordance with law. They failed to do so, my lord.
You don't want to file an
We will file, man. We will file.
additional affidavit.
We will file.
Then-
Lordship, give 1 week time.
Mr. Chamaria, learned counsel for the petitioner, prays for and is granted 2 weeks further time to file, 2 weeks time to file additional affidavit to bring on record certain documents he submits would have a relevant bearing in the matter. Para, Mr. D. Nath, learned senior government advocate, has produced the record. What is your file number?
File number is just below the letter, Malad. Malad, just below the letter. Till- Under the letter, Malad. In the letter also it is mentioned.
Double AP top 09/2022
Last
part.
note, last note.
In terms of the earlier order dated 6/12/2023, these records were produced. And on 5/1/2024, the petitioner was permitted to go through the records. Stop. Accordingly, the matter stands deferred for another 2 weeks, by which time the additional affidavit as prayed for may be filed. The respondents will keep the relevant records, including all part records, ready for perusal of the court on the next date if so required.
But I just would like to indicate.
The records produced before the court are returned back to the learned senior government advocate. Yes.
Malad, just to indicate, Malad, that the last note sheet in the available in the file, they have taken a decision to proceed in the departmental proceeding. So the record is required only for that purpose. They may require that record. In this file only.
No,
the
no,
last
you have
note-
to show how the extensions were done.
Yes, extension that I will place.
That is not here.
Malad, first extension is there.
First is there, subsequent, third,
Yeah, subsequent, I'll definitely.
these are not here.
I'll definitely put it. Malad, since it is not a pleaded case, Malad.
And
I'll
also,
Continuity, my lord, the matter has been seized by the honorable court. He wants to say that why I have not bought earlier, my lord.
No, he has not pleaded
Just in
nothing.
the month of
nothing.
November, they have issued extension order. This
No,
matter has
no.
been seized by the honorable court, my lord. Everything has been perused. Now he is saying that, my lord, why I have not bought only.
beg the records. Yes. After 2 weeks.
Lordship, may I pray for date, my lord?
Huh?
May I pray for date, my lord? Any date. Any date.
All right, 2nd of February.
My lord. Deeply.
Yes. What information have you brought?
My lord, petitioner, husband of petitioner has been granted earned leave. Also, my lord, the file regarding my lord supernumerary post has been returned by finance, seeking some checklist, and we have forward, and that there is a OM in operation, my lord, which says, my lord, we have to take certain views from the judicial department. That file has been sent.
How does it help the petitioner?
Huh?
What is the
The
effect
files are
of-
moving, it will lead.
Files
to
are moving.
creation. Files are moving. It will lead to creation,
That was the only,
and there's an OM in place how to create supernumerary posts. It's a OM of 2018.
There is no direction by the court to the department not to follow it. We follow it.
No, that is,
Question
I'm
is,
indicating that it's being followed and we're in the process of creating that. And apart from that, my lord, a period of 139 days has been given as a
earned leave.
earned leave.
All right.
Now payment is subject to, my lord, clarification of clearance by the AG. Copy has been marked.
Yes, AG.
Biotech instruction plan and ensure that the payment is made immediately.
Lordships, I do not understand these submissions which are made in a piecemeal manner. On every occasion, this honorable court has to tell them that you do this, only then I will do it. This has been continuing for the last 1.5 years.
You get it by Friday. Get it by Friday. Tell us what instructions, what information are further required.
On the other side, my lord, we are doing whatever is needful, my lord. It's not that it's only on the
You're
instruction.
not
of the-
doing the court or the petitioner
No,
a
it's
favor.
not.
You are
It's
under
not
a
as
bounden
in-
duty
no,
of
no, my
the
lord, it's
statute
not as
to create a
agitated
post.
that only the when court intervenes, it's not like that, my lord.
No,
It's
no.
moving.
No. Moving is not satisfactory. It must move to a particular direction and rest there.
It is
It
going to
cannot
that.
be perennial.
It's going to that
perennially
destination, my
moving.
lord. Perhaps, my lord,
No, Mr.
it is moving, my lord.
Mr. Gogoi,
My lord, we are not
Whatever,
disputing anything.
whatever rules, regulations you may say, it is a law created by the statute.
My lord.
Lordship, that is
You
not-
are, you are, as on date, you are not following the law
We are
created by
following,
the
my lord.
statute.
That is the, in these steps indicate that.
No, these steps do not indicate it has been complied with. Steps, as you say, indicate that you are attempting to comply with it.
No, no. We are taking the steps as required, my lord, for the creation, because we are not disputing. We are trying to help out the petitioner. We are not disputing that he is not entitled.
There's no question of
We have
help.
accepted, my lord, that
Lordship,
they have.
No question of help. You have to do it.
Right?
That is, we
It's
are
not
trying to
an
help out, my lord.
assistance which he is trying to give me. I'm sorry.
There's no question of
We are
help.
not disputing also, my lord.
Right.
We are fully agree,
You are
fully in
in no
agreement with the
position to
petitioner, my lord.
dispute,
No,
my
now,
lord.
Now the steps, my lord, are taking
what,
are
what
just indicated, my
steps,
lord.
what steps are
Lordship, we can
necessary?
read the letters. One, my lord, the first page is
Hmm.
earned leave, to which my learned senior friend has said he will bring instruction on Friday. Another, my lord, will see the chief engineer having asked to provide a checklist. And also, my lord,
No, 7, 8 and 9. What is 7, 8 and 9?
My lord will see that OM says, my lords, on the complete third page, my lord, 7, 8 and 9, there is a checklist, my lords. Total financial implication involved, head of account and budget provision, and 9, whether the pay and allowances of superintendent post are in conformity with the ROP of the country corresponding period, and 10 is, my lord, views of the judicial department, if it is where there is a court case.
Lordships,
Yes.
the communications with my learned friend has placed today, which never, a copy is never supplied to me. In any case, your lordships will find that your lordships order of the last occasion was of 20th of December. And your
Yes.
lordships will note that the letters which my learned friend is producing today is of 8th of January 2024, which is today. Which basically means that from 20th of December till 8th of January, they were sitting over the matter doing nothing. And only because the matter is in court today, they hurriedly issue these letters on a regular basis. On every occasion, the same thing has been happening.
Therefore, we are fixing it on Friday.
Lordships.
You tell us what steps have been taken regarding
Request
7, 8 and 9.
Thank you.
7, 8 and 9 should be half a day's work for the chief engineer's office.
Chief engineer office will require some time, my lord,
Why?
by
Total
Friday.
financial implication, head of account, pay and allowances of the supernumerary are in conformity with the ROP or not, then?
In
Now,
that case,
how-
lordship can dispose of the matter with the outer limit of 2 months.
No, lordships, I have second round of
If that be so,
litigation,
my lords, if that
contempt
be
case
so-
against them, and this is the
Let
attitude, your
because
lordship.
I am not the authority, my lord. Let the authority face the contempt.
Second,
Let the authority face the music of
Yes.
contempt, my lord. Let the matter be disposed.
yes, your lordship, in
Let
that
it be
case, let me press for the contempt, your lordships. Let me press against the contempt.
If that is, my lord, it's going on. I'm being questioned as if I'm responsible, my lord.
No, you are not responsible,
you, I
but
don't
then
mean
you are responsible perhaps for not conveying it to the.
Letters on 6, as we have advised, as to issue letters on 8.
No, Mr. Counsel,
Let the matter be
You-
disposed of. We'll do the needful within 2 months.
you are giving an undertaking.
Yes, my lords.
No, your lordships, I do not agree to that undertaking, your lordships. I apologize, but I do not agree to such undertaking. That undertaking was given, that direction was issued to them in the earlier writ petition, against which a contempt is pending against them.
All right, let us have it on Friday.
All right, my lord.
We want you to update us on your instructions,
My lord, the payment part
In-
AG will come.
including PhD.
My lord, if that checklist
On
has
the
been-
basis of this checklist, whatever instructions you have done. Friday is what? 12th. List again on 12th, on which date the respondent, particularly the learned counsel for the PhD, Mr. Gogoi and Mr. or Mozumdar, appearing for 5. We'll update, we'll apprise the court of the required instructions in the matter. Mr. Das for who is 6 and 8?
Ki naam hai uska?
Social justice and empowerment.
Respondents number 6 and 8.
All right, my lord.
Lordship, my learned friend should not take it personally when I say they are
No,
not.
no, he
I
doesn't
did not
take personally.
not
I
doing
was
anything.
countering that, my lord, that
Lordship,
authorities
my
of
lord,
today
No,
is
we are convinced.
He has done exactly that.
We are convinced he doesn't take personally. Yes.
All right, my lord.
Other than this matter, we are directed to file an affidavit.
Hmm.
We're filing it during the course of the day, my
Yes, Mr. Dubey.
Let him, my lord. Can it be taken immediately after view vacation, my lord? But the issue is sought, my lord. Within the last year of his service, he has been sought to be transferred. And my lord, that your
Is
lordship
there
has-
a bar?
Yes, my lord, bar, my lord, procedure says that it should not be, but it has been done in a manner.
All right, let his affidavit come. Matter be listed in 2nd of February. Uh, all right, 22nd of February.
My lord, only thing, my lord,
22nd of January, by which date the respondents submit that their affidavit, they will file their necessary affidavit.
my lord has fixed on
22nd
January.
January.
I think that they are not making payment since, my lord, they
Let
initially
their
did not.
affidavit come. Let their
Yes.
affidavit.
Ajit, देखो.
My lord, this matter may be passed over for time being, my lord.
31.
Yes, my lord.
Lordship, in this matter, we have received one instruction and we are preparing affidavit, Lordship. So we may be allowed the 2
Lordship,
weeks time, Lordship.
Lordship, we have filed one miscase, Lordship, that has to be moved today, my lord. Mr. D. Das, senior advocate, he is leading me,
All right, at 2,
Lordship.
at 2 p.m.
Okay, Lordship. Oh, miss this, I agree.
Lordship,
Yes.
Lordship, instruction received, my lord.
Instruction received.
Revocation of suspension.
Huh?
It's
Revocation.
for revocation of suspension. They have received their instruction, they want to file an affidavit.
All right. Any objection?
No.
Okay. MS M. Das, Learned Standing Counsel, PWD,
My lord.
submits that instructions have been received and she would like to file an affidavit. Mr. D. Chaudhary, Learned Counsel for the petitioner, does not object. List after 2 weeks.
Date may be. No.
Date. 22nd.
Much.
29th January.
Much.
Lordship, kindly pass over the matter to 5 minutes.
Yes.
May I please, Lordship?
Yes.
Matter pertains to revocation of suspension, Lordship. Last attorney, Lordship was pleased to direct them to obtain instruction and file affidavit, Lordship.
Yes, any instructions? SSA.
On the last occasion, elementary education was directed to obtain instruction.
Not elementary, secondary.
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 And as well as you, because your name is recorded here for respondent number 3.
Pertaining to that, your lordship, we have sent our communication later, your lordship.
MSP Das, Learned Counsel, appearing for respondent number 3, submits that instructions are awaited. She prays for further time. Mr.
S.H. Ram.
S.H. Rahman, Learned Counsel for the petitioner, does not object to the prayer made. List after 2 weeks.
May I pray for fixing it?
29th January.
Obliged.
Deeply obliged.
Yes, Mr.
I'm
Ratna.
sorry, my lord. Here, my lord, it's a suspension, my lord.
Hmm.
Whether here's not for the instruction, my lord, whether his suspension has been reviewed within the period of 90 days or not. In the last 5 occasions, my lord, they have taken time, my lord.
Who is for the respondent?
It doesn't. My lord, on the last occasion, my lord,
Yes. Yes, Mr. Khatuniar,
30.
review.
33.
Yes, my lord. There was no review as on today, my lord, but inquiry was completed, my lord, and we are going to reinstate him. Within a week, my lord, order will be issued, my lord.
Enquiry, my lord, I think, my lord, there is a wrong conception, my lord. The lordship may see the last order passed by this court. My lord. Enquiry before that, my lord.
Preliminary.
Yes, my lord.
Yes, my lord. No, that is
There-
not entry record. My lord, I have the record also, my lord. Today I have got the record also, my lord. We are going to reinstate him within a week, my lord. Maybe after review vacation, my lord. In fact, reinstatement order is also ready.
Can we record your statement?
Yes, my lord.
Can we record it? Heard Mr. N.J. Dr. Learned Counsel for the petitioner, Mr. N.J. Khatunian for the respondent department. Which department is this?
Second, elementary education.
Elementary education. The petitioner has assailed the suspension order of the petitioner issued by the respondent department. And the further prayer is that the suspension order is required to be revoked as no review of the suspension as required by law was conducted by the authorities. Stop. There are on earlier occasions opportunities were granted to the respondents to complete their instructions. Stop today when the matter is called up. Mr. Khatuniar, Learned Standing Council, Secondary Education, submits that submits as per instructions received that there was a preliminary inquiry conducted and pursuant thereto, the authorities have decided that the allegations.
No, it's not a preliminary inquiry, my lord. It's a
Then?
departmental inquiry, my lord.
Departmental, but have you served notice and all that?
Yes, my lord. Notice Annex 59.
No, no.
Huh? Or you write that the inquiry conducted against the petitioner, pursuant to an inquiry conducted against the petitioner, the authorities have decided to reinstate the petitioner. The effective orders are likely to be passed within a period of 1 week. And accordingly, he submits that the matter will be deferred. By 2 weeks. Mr. Doctor doesn't object to the prayer made. Accordingly, lists the matter again after 2 weeks. List on 29th
Right.
January.
Obligado.
The Youngest Council, they have been, my lord, out of station, my lord. So,
Nothing is surviving here. We dismiss it.
my lord,
You come back
I have
again.
I have no file also, my lord, and
Who is the engaged counsel?
J. Abdin, my lord.
Huh?
Jainal Abdin, J. Abdin, my lord.
Oh, what remains there?
Is out of station, my lord, as per his telephonic instruction.
When is he likely to be back?
My lord, after, my lord, any date, my lord.
Huh?
After the vacation, my lord.
19th. List. Sorry, 19th, 18th. It is submitted by, on behalf of the Learned Counsel for the petitioner, Mr. J. Abedin, that he is out of station and has submitted, and his leave of absence is also reflected in the course list. Prayer is made to list the matter after the ensuing Bihu vacations. Till when is he absent?
Vacation, my lord, be
All right, list on 18th January. 18 January for hearing. None appears for the petitioner. For the parties on called. Passed over.
In these matters, the key was supposed to appear,
Hmm?
but then the key senior standing counsel was supposed to appear, but his son has taken ill this morning suddenly. Madam. So
Who's appearing?
the key one.
Does anything survive here?
Yes.
What is the issue?
Issue lordship, the petitioner was appointed in the post of LDA in the office of principal Assam Engineering Institute by the order dated 6/9/1961. Thereafter, the petitioner was released from Assam Engineering Institute by the order dated 31 March 1967 to join in the office of PRTC, Panchayat Trust Training Center. And thereafter, the petitioner was appointed as UDA in the office of PRTC by the order dated 4/3/1967. Lordship, the service condition of the PRTC employee is same as the government servants, but they has been deprived of their service security, confirmation, pensionary benefit, etc. Thereafter,
What is the PRPC?
Panchayat Trust Training Center.
Panchayat Raj Training Center. It is what? It is established by whom?
It is established with the aim and objective of rendering training facilities to the
No, but no, by who has established this?
uh, uh, it was established by government letter number PTP 744/61/75 dated 26 March 1962.
What is the name of the petitioner?
Name lordship. Rajendra Chandra Kumar.
Huh? Rajendra Chandra Kumar.
Yes, sir.
After the order of the court earlier in 4140,
Yes, okay.
page 23. Page 23.
Yes, sir.
Any order passed by the department?
They neither pass any order nor approach nor file any appeal challenging this order. It came to the knowledge of the petitioner in the year of 2008. Lordship may have a look at Annexure 8. That only one among the petitioners, only one petitioner is considered by the department. Page number 47, Annexure 8. May I read, Lordship?
Yes.
Since Sri Siddheswar Burua was in government service before joining the service of PRTC, and thus his services at PRTC may be treated as on deputation. Not they didn't say that he is on deputation. He may be treated on deputation.
Yes, Mr. Devnath. Any affidavit filed?
My affidavit filed in item number 39 by Department Finance Department, Lordship.
Finance.
Not in-
Saying what? Page number 23. A second file to details. In the second file.
Page number?
You see the second file, page number 23. There is an order of a coordinate bench earlier. Come to page number 29.
Yes, sir.
Paragraph 9. There was a direction by the court while disposing of the matter. There is a finding by the court.
38, item 38. 38.
Page 29, para 9.
Yes, sir. When the matter has been taken up.
Yes, yes. Below that, sub-para.
The Commissioner and Secretary of the Government of the Panchayat and Rural Development Department shall consider the case of the petitioners and.
This is the direction of the court disposing of the matter. Right? So read further. This direction of the court.
The Commissioner and Secretary of the Government of Assam, Panchayat and Rural Development Department shall consider the case of the petitioners and pass appropriate orders in order to declare the petitioners as government employees so as to make them.
So the direction is to declare them as government employees. Whether such orders were passed.
Well, actually, the brief is not with me and brief one is actually.
Therefore, we are bringing it to your notice. On the next date, you get your instructions with specifically with regard to that. Whether any orders have been passed or whether any appeal or review has been filed against that order. 38, 39, right? It is submitted by Mr. Devnath that Mr. K. Kuar, additional AG, will appearing for the respondents is indisposed and therefore the matter be deferred for some time. What is your name?
KK Mehdi.
Mr. K.K. Mehdi appears for the petitioner. Let the matter be listed again on On 18th. Not 18th. 23rd. 23rd January. Yeah, for the respondent.
Yes, my lord. It's a 14 years ago matter, my lord.
What is the
My lord, he has challenged my appointment.
your appointment?
Yes, my LB.
You're retired now.
Foreigners Tribunal Tezpur.
So you are retired now.
No, I'm not retired. I'm still working. my lord.
You're working.
Yes.
You are respondent 7.
Yes.
Where is the petitioner?
My friend Sarkar, I do not know. I think he has lost the interest, my lord.
You inform him if he's available. Second up, you intimate the court master.
Sure.
Otherwise, it gets referred. Itu যদি খবর দিয়ে at 2. Yes, at 2.
Item number 44, madam, the Central Government Council perhaps is not available today as informed to me. If he can
Item
please do some-
44, at the request of Mr. Mazumdar.
My lord, Mr. CGSC, madam.
KK Medhi appearing on behalf of
Mr. Medhi, SK Medhi. At the request of Mr. SK Medhi, CDC, matter stands adjourned for 2 weeks.
Could a date be fixed, madam? The dismissal matter, young boy, madam.
Date will be fixed in March. Huh?
Little bit 2 weeks, madam, I'll have it. Listed prior to the
13th February.
so blessed.
Fixing code number 2, Lordship. One hearing matter is going on, Lordship.
What
So-
can be done?
Lordship, maybe after some time, date may be fixed, Lordship.
Therefore, the matter was kept at 2.
Lordship. Lordship, but the matter is going on, Lordship, from 11 AM to Lordship. It takes sometimes, Lordship.
What is your grievance here?
Lordship, the petitioner has not given his salary, Lordship, including the current salary, Lordship. But after the filing this petition, Lordship, notice was issued. Receiving the notice, Lordship, the respondent number 4 released salary of from the month of April 2022 to November 2022. Thereafter, he has not Lordship reduced the salary, Lordship. And the stand of the respondent number 4 is that the petitioner is not Lordship regularly attending the office, Lordship. My humble submission is that, Lordship, if the petitioner is not Lordship attending in the office, Lordship, he may issue suppose or any other, nothing has been done, Lordship. He has done it after receiving the Lordship notice from this honorable court, Lordship. And these suppose was also not received. In fact, I have stated what happened I have stated in my affidavit in reply, Lordship. There is some, Lordship, the respondent number 4, Lordship, who is the PTO, Lordship, he is not willing to accept the petitioner here, Lordship, to apply. This is the main problem, Lordship. And the problem is there, Lordship. I have stated in categorically here, Lordship. And he has from 148, Lordship, in my affidavit, Lordship, I have categorically stated, may I read, Lordship? In fact, the respondent number 4 not only refused to accept the joining report dated 27/12/21 of the deponent, but also suggested the deponent to approach the departmentally for modification of his transfer order, with the saying that it may be difficult for the deponent to perform duties mostly at Sapegadi Development Block, as some linguistic activities are very much active in that area, and the deponent is from linguistic minority community. After such refusal, the deponent then approached the office of the chief executive officer, Jila Parishad, but could not meet with the chief executive officer at the time. Thereafter, on 29/12/21, when the deponent submitted representation, Lordship, I have annexed it to my repetition, Lordship. After submitting this, Lordship, representation Then he accept my joining report, lordship. Thereafter, lordship, this problem starts, lordship. And since then, the respondent for being offended has been harassing the defendant in many ways. The respondent who himself admitted in his affidavit the defendant was not allotted any specific duty by him, but he took a plea that the due to absence of defendant at his office till 9/3/2022, the respondent number 4 could not allot the specific duty to the defendant. But it's a matter of astonishment that on the other hand, the respondent number 4 himself admitted that for past time he allotted a work duty to the defendant by order dated 15/10/2022, which is apparently after receiving the notice of instant repetition from his honorable court and not before that. Whereas the respondent number 4 must be allotted the specific order duty to the defendant on the date. Lordship, the respondent says that only these dates, lordship, the petitioner was lordship present, lordship. If he is required, lordship, the respondent on the days and of the days when the respondent was present at his office as per statement of respondent, but as to why the respondent number 4 did not do so. Therefore, it is crystal clear that the respondent number 4 willfully with malevolent intention only to harass and deprive the respondent not to allow the strategic work duty to him. Moreover, the respondent number stated that the respondent was unauthorized absent in his office till 9/3/2020 after his joining and therefore allotted in attended in office only on 10 date. But it is a matter of surprise that if the respondent was all along absent from his office unauthorized, as alleged by respondent 4, as to why the respondent number 4 has neither issued any shock cause notice to the respondent nor informed the same to the higher authority earlier, yet only issued the purported shock cause notice dated 28/12/2022, just after receiving notice from this honorable court in connection with the inter-dispute. Whereas in fact the respondent did not receive any such shock cause notice dated. As such, the question of reply to such is done only. Apart from that, although it is allegedly stated by the respondent number 4 that the department was all along absent from his office except the date mentioned above, but in Shockers notice dated 28/12/2022, lordship, it is in page 102, lordship, he stated that the specifically mentioned that the department was totally absent from 1st December 2022. Therefore, it is clear that the statement of respondent 4 are self-contradictory and baseless. The respondent number 4 being the custodian of the attendance register cunningly has taken the plea of unauthorized absence of defendant for illegal non-releasing his monthly salary, believing the fact
Come to
that it
page
may be
number 97.
lordship,
Come to page number 97. Page 6.
97 of
No, page 6 of the affidavit in opposition.
page 6. Page 6.
There is a specific statement here
Okay.
that you attended office only for 6 days.
Lordship, that habit I have stated, lordship, in my reply, lordship, I am.
No, in your reply, you have not referred to this paragraph. You have
Yes.
given an omnibus statement.
No, lordship, I have referred, lordship,
Where?
lordship. And
Para 3.
where are three, lordship? I have sum up his statement and thereafter submitting my reply. From Roman 1, lordship, my submission.
Now, what do you mean refuse to accept?
Lordship, he suggested the petitioner to lordship for modification of the order and I have stated it, lordship. Thereafter, lordship, on 29/12/21, lordship, petitioner submitted a lordship representation before the principal reader. I have annexed it with my repetition, lordship.
Yes,
Then lordship, he
then-
did accept my lordship. Joining report.
Then?
Thereafter, lordship, the problem starts, Lordship. He is harassing Lordship.
Now you are claiming salary for which period?
From Lordship, from the date of joining, 27/12/21,
Date of joining.
Lordship, 27/12/21. But he have, from the date of joining from 27/12/21, but after Lordship issuing notice in this case, Lordship, the respondent released the salary from Lordship April 22 to November 22. Page 98, Lordship, affidavit in opposition number, page 98. And it
No,
is humbly
what
submitted
is
to
the
those of-
period for which you are asking? From
Lord-
27/12/21 till which date?
till date, Lord.
But you said current salary has been released.
Not released, Lordship. Current salary is not giving, Lordship. Just only receiving the notice, Lordship. He released some months, Lordship, from April 2022 to December, November 22. In his Lordship, annexure, Lordship, page.
Is there no other standing council here?
Lordship is placed in court number 2, Lordship.
Is there no other standing council?
No, Lord.
For the PNRD department, there is no other standing council.
No, Lordship. Today is not available.
Huh?
No, Lordship.
No, are you understanding the court
Lord-
question of the court? I am asking you whether in PNRD there are,
Today is not available, Lordship.
none of the standing council.
Lordship.
Yes, government, what is this? Not a single standing council is available.
For today, Lord.
No, so what are we supposed to do? No prayer for adjournment was made in the morning.
The last occasion also, Lordship.
Lordship, kindly matter may taken after some time, Lordship.
And Lordship, at least his current salary may be directed to release, Lordship.
All right, after some time, please ask him to come. Ask him to come before the court rises. Today,
Lordship. Lordship.
after some time. Yes.
Item 31. I'm sorry, my lord, the matter was called for.
Some IA has been filed.
Yes, my lord, in this case, what was the main case and why we filed an IA? My lord will kindly take the main case first.
Hmm.
My lord, the particular petitioner before your lordship was the joint director. He now is superannuated. Now at page 49, a SOCOS was issued. Kindly look into my lord SOCOS.
Hmm.
Kindly see first paragraph, only one paragraph I'll read of the SOCOS. 17 November 2018. 1. That while you were in service, Joint Director of Information and Public Relations, an amount of 30 crores in odd was allotted for implementation of scheme Vision Assam, Mission Assam. Said amount was misappropriated by DIPR as alleged by the ADGP, CM Special Vigilance Cell Assam by this inquiry report, part 1 of so and so. You have aided and abetted in the then DIPR in the entire scam. Further, you are also a party to the conspiracy which ultimately caused misappropriation of public money amounting to so and so, so and so. Now, on the basis of this, this is a mail. Now, on the basis of that, we file a reply at page 57.
Hmm.
Kindly see at page 57. Reply was filed.
Yes.
Now, at page 63, kindly see page 63. And in the year 2019, an inquiry officer was appointed
Hmm.
at page 63. And at page 64, presenting officer was appointed.
This is of 2019, Lordship will kindly mark it,
Hmm.
15 February 2019. At page 65, 10th of June 2020. Now, the petitioner is retired from the service. He gets superannuated on 30/11/2020. Lordship got it, my lord? 2020. Now, I represented the matter before the government at page 66, that is 28/2022. They pay my pension. Whatever benefits I supposed to get it, you pay the benefit. Provisional sanction was granted at page 67. I got the provisional sanction. Now it's very important at page 70. Now, in respect of the director, they said I am the aid and abettor. At page 70, 73 kindly be looked into it. 70, 71 kindly be looked into it. This we got the inquiry report. Now page 71(1) with reference to charge frame as serial number 1. That is my lord serial number 1 which I have showed. Misappropriation of public money amounting to 30 crores so and so. Government office of power and thereby violation of rule 3 of so and so, so and so. So this is was leveled against the director. Now director, they said I am the aid and abettor. Kindly see the finding at 73. That is the charge number 1. 73 last recommendation. Charge frame against the delinquent officer is not correct in totality. Hence, for avoiding repeat nature of that may be dropped. So what our case is that if it is dropped against the director, and by the time director retires, my lord, and he gets all the benefit. He gets all the benefit. There is a criminal case against the director which is going on. I was never placed under suspension. Never placed under suspension. No criminal case against me. Now I come up before this court, my lord, on 2 counts. One count is I superannuated from my service. One is that once I superannuated, my lord, all the preliminary inquiry, which was so-called with an inquiry officer, the presenting officer has been appointed. These are all preliminary. Before my superannuation, whether any charge sheet has been filed or not. This has not been filed. Now your lordship knows under 21 of the Assam Service Pension, the Assam Service, lordship will kindly see, Assam Service Pension Manual. What is this 21, my lord? Earlier you have to say take sanction of the governor. Now it is not required. It is automatic. Whether before superannuation, if any so-cause has been issued, that will amount to continuation of your service. That is now there is an amendment to it, 21. Now there is one judgment of the Supreme Court, which on when I moved the matter, I pointed out before this court. There is a judgment of the apex court. There was a proceeding in respect of a bank employee, where the regulation says if there is some misappropriation which takes place and it is charged, then it says under regulation as if it is not a case. Suppose if superannuated also, it is amounting to continuing in his service and he continues unless the proceeding is not being over. Then it travel to the apex court. Apex court by judgment says, no, that regulation is not correct. Why it is not correct? That regulation should go. Once it is before superannuation, these are all preliminary inquiry. Charge sheet has to be filed before superannuation. So that was the ground where we moved before this honorable court. Absolutely, you have not done anything from 2018, 2019, inquiry officer, presenting officer, I superannuated. Now what has happened? Why we filed this miscase before this court? When the notice was issued by this court and court said that, okay, we'll hear this matter, and the matter was fixed. I think on today it has been fixed. Today it has been fixed. In the meantime, what they have done, they have issued a notice to me. That notice in the miscase, you will kindly find it at page 19. They said inquiry. page 16, kindly see. How can they bring the inquiry against me and that to 2023? Kindly see at page 16 of my miss case. Kindly see page 16, the miss case.
Yes.
Government order dated 19/9/2023. Enquiry. With reference to you are hereby requested to attend for hearing in connection enquiry by order on reference on 14/12/2011 a.m. So where is what is this, my lord? When it is in session before the court and we have asked for entire that this should go and my retirement benefits, regular benefit.
This is what inquiry?
I'm sorry, I was a joint director.
No, what inquiry?
I don't know what inquiry. And that is your lordship government order dated 19/9/2023.
What is that order?
I don't know what is that order. We don't know what is that order. I could have very well understood that is in connection with the earlier so-cause.
So what happened on 14/12?
No, nothing has happened. Nothing. We prayed for time and we said these are matters in session before the court. Well, they should not proceed with this matter. How can they proceed when a matter is in session before the High Court? Let them file a reply, but they should not proceed with this inquiry. I don't know what is the inquiry of. Nothing reflection about the earlier so-cause notice also. So-cause. Kindly see my writ petition. This is of 2018 so-cause. And this is about the miss case.
When is the matter fixed next date?
Next day. No. It's date they, I've been told a date they have not given.
But on 14, nothing happened.
Nothing happened because they know these are cases which are pending. And my lord, 2023, I don't know what is 2023. And they know also that was our submission
No,
before the court.
in the IA,
Yes.
you are aggrieved by that notice only.
Yes, only by notice. That notice, they should not proceed, that's all. Till your lordship decides the issue. And the main director and the,
But there is no stay here
which one?
in the inquiry proceedings.
No. The court said we'll try to dispose. We don't want also, my lord. What we want, let it be disposed of. Because we will say that, my lord, if the main director, my lord, nothing has been found, it has been dropped. And they said we aid and abettor of the main cause. So what remains in this proceeding, my lord? And secondly, whether after my superannuation, a charge sheet has not been filed, legal issue, my lord.
No, charge sheet means in the criminal matter.
No. In a departmental proceeding also, a charge
Means
sheet. One is a criminal matter. One is a preliminary inquiry. Preliminary inquiry, thereafter, a memo of charges. Memo of charges. In a disciplinary proceeding, memo of charges, my lord.
What is at page 42
Page 42.
of the writ petition?
Yes. 42 is a so-cause. It's a preliminary.
Against whom?
Against the petitioner.
It's a preliminary.
Yes, it's a so-cause inquiry. My lord, this is inquiry officer is a presenting inquiry officer, presenting officer. Then only, my lord, the memo of charges. These are all preliminaries. They have appointed inquiry officer. I given a reply. Then after memo of charges, after the presenting officer. Presenting officer will charge. These are the memo of charges against you. This has not been drawn also. I am raising a legal issue in this case, my lord.
No. Pursuant to show cause, you replied.
I replied.
Then
they appointed inquiry officer.
Inquiry officer.
At page 2019. Then at page 64, a presenting officer.
All right.
Now what they will do? What is their duty? Their duty, they will go into my reply. And they will a particular memo of charges. If they find nothing. Otherwise a memo of charges. They will draw. These are the memo of charges against you.
That is already there in the
There is
show cause.
not there. No, it's not that.
Statement of allegations
No,
are there.
This is only a preliminary. What the apex court said, these are all preliminary.
Let us see the judgment.
Yes.
Under what proceeding, under what rules these proceedings are initiated?
Which one?
Discipline and appeal.
Discipline appeal rules.
So the
Under Rule
discipline
9.
and appeal rules are clear on this.
No, I think, my lord, that's what I like to place before this honorable court, my lord.
Hmm.
These are all inquiry. My lord, ultimate presenting officer will give a chance to you of a charges leveled against you.
Exactly.
And
On the
yes.
basis of the show cause and the
No,
reply.
Yes, where is that? On the basis of so-called memo of charges, he has to come to some preliminary finding he has to come in.
Which paragraph?
Yes. One second. My lord will kindly paragraph 21 kindly see, my lord. Paragraph 21.
Yes.
While interpreting the 1979 lordship got it, the court opined that the legal fiction created in clause 3 of the sub-regulation 23 of the 1979 regulation must be given full effect. 2023. SEC online SC 1327. But it is well settled. Scope and ambit of the legal fiction should be confined to the object, purport for which the same has been created. It was opined that 1978 regulation could be invoked only when the disciplinary proceeding has been initiated prior to ceasing of the employee service. The delinquent employee would be deemed to be in service although he has reached the age of superannuation. That the regulation says, Mike. Only if a valid department proceeding has been initiated. The department proceeding was not initiated merely on issuance of a so-called notice. It is initiated only when a charge sheet is issued. This is the date of the application of mine on the allegation level against employee by the company authority. Pending of a preliminary disciplinary inquiry by itself cannot be a ground for invoking regulation 20 of 1979 regulation. One an employee having been allowed to superannuate only proceeding inter alia including withdrawal of his pension or any other retirement dues under the application regulation could have been initiated. And in that case, charge sheet was issued after the employee has been already superannuated. The same along with the inquiry report, order of punishment was set aside. Order of removal or dismissal from service can be passed only when an employee is in service. Only if it is in service. If the person is not in employment, the question of terminating, this was a different terminating his service by regulation, he was continuing. Some preliminary departmental proceeding was going on, but there was no memo of charges which was filed. Only after superannuation it was filed. This is what it contemplates, my lord. Well, this is an issue where your lordship has to hear this, they have to file a reply.
No, but in the context of the Assam rules, you show us that such a provision is applicable in as discussed in the judgment.
No, my lord, this is a regulation. On the principle, I am taking the.
No, the principle will be dependent on the rules, state
Yes.
rules. State rules does not say so.
No, even the state rule, my lord. Here the regulation was set aside.
But
My lord.
we are concerned with the rules.
I know, where is the state rule? State rule also the same principle, my lord. I will show before your lordship how a departmental proceeding is initiated. How it is initiated, my lord.
Yes, madam, what do you say?
When the inquiry was initiated, lordship, and the inquiry officer was appointed, lordship, thereafter the concerned inquiry officer has left on deputation, lordship. He has been gone to some other department, lordship. And thereafter, presently, one new secretary has joined. And
No. In respect of the IA.
lordship, in respect of the IA, lordship, the matter is going on. Even today, the date is there. And on last 14th, the petitioner was supposed to appear.
Oh,
And
what-
he has.
What inquiry? What inquiry?
Lordship, this inquiry that was initiated earlier, lordship, this is
Okay.
going on, lordship. And the petitioner has submitted his application, and due to health ground, he is unable to attend to depose before the inquiry officer, lordship.
When
today
is the
also-
next date?
Today also, tomorrow is also another date, lordship. Today also two witnesses have deposed before the statement has been recorded, Lordship. And altogether more than 8 persons witnesses have deposed before the inquiry officer, Lordship, and the statement has been recorded.
The inquiry has already commenced.
Yes, Lordship, it is going to day-to-day
How we
basis,
can go
Lordship.
ahead with the inquiry, my lord?
We don't know that is.
No, my lord, one thing I am just telling you, lordship. When the matter is in session, there is no stay because we have given a consent to read that they will file affidavit. Behind our back, they have gone ahead with the inquiry. They could have taken leave of the court that yes, we are going ahead with an inquiry.
No, but there is no stay.
No, my lord, this stay we have said to the court that they are going to file an affidavit.
We will file affidavit,
No,
Lordship.
if that
We
be the
have
case,
received information,
from tomorrow
Lordship.
onwards, my lord, each and every case I will start registering, my lord. If that be the case, they take the advantage out of it, then I will start doing it, my lord. But we will not give any consent. If that be the case, at least they should have taken leave of the court. And we have told the court also while moving the matter. And they have taken the advantage. Now the position is such, my lord. Definitely your lordship finds it difficult because what we will do it because they have started going ahead with the inquiry. They have started witness, 2 of the witnesses has been deposed. There are other witnesses. I know, my lord, these are difficulty they will place before the court. And your lordship is, it will be difficult.
But there was no, I don't know, but there is no prayer for stay as seen.
There, so nothing has restrained.
No, no, that's the whole
Only
problem.
notice was issued.
There was
My lord, that's the whole problem, my lord. Taking the advantage, then it's okay, fine, my
Oh,
lord.
no.
No, it's okay, my lord, fine, my lord.
This is not admitted,
Eh, eh.
Lordship. Other persons are
No, it's
also
okay,
involved
fine,
here,
fine,
Lordship.
fine. You
The
are not there
petitioner
at
is
that
not the
time.
only person,
Absolutely.
Lordship. The
And-
other persons who has been named, Lordship, they
My
also
lord,
have.
I will leave this case. Let them say director is what has happened to director. We are the aid and abettor.
Yes,
What has
Lordship.
happened to director?
Lordship.
Yes.
The director has been that means imposed penalty. He has to go on forced retirement, Lordship. And the period of suspension, Lordship, this has been that means he is not entitled for anything other than only counting of pension only. Lordship, it is there. And thereafter, Lordship, regarding his pay and allowances, Lordship, and admittedly he has got the provisional pension. Then, Lordship, the final amount of GPS has already been that means he has got. Then the other leave encashment, then the application for accumulation of state government GIS, Lordship. This has already been, the department has already forwarded before the accountant and Lordship.
When do you want to file your affidavit?
Lordship, for respondent number 5, Lordship, we can file it within a week, Lordship. But for the government, Lordship, it will take a little bit because the witnesses are being examined, Lordship. Tomorrow also there is date and most probably these are on the verge of completion, Lordship. So we'll file a detailed affidavit on that. Kindly allow us 3 weeks time, we'll be able to file the affidavit on behalf of the government, Lordship.
No, but you see, the entire proceeding is under challenge. Now, if you complete, by the time you file your counter,
Lordship.
if your inquiry is completed,
Lordship.
what is to be decided here?
Lordship.
You either you file it within
Lordship.
1 week, or you
Lordship.
produce the records, the court will hear the matter.
That we can, Lordship. Lordship may.
Then we can hear it. Otherwise, if you proceed with the
Lordship.
inquiry, if you complete the inquiry, then
Lordship. Because there is no bar, Lordship, and we are not been prevented that we cannot go with the inquiry, Lordship. Nowhere it is been
5
paid also,
years.
Lordship, that
5 years,
they could
please.
not get.
5 years you said.
since when
5
did,
years you sat down. 5 years you have not done
since
anything.
when did you proceed with the inquiry?
Huh.
When was the inquiry proceeded with?
The exact date I don't have, Lordship.
In 2018, they were keeping quiet, my lord. Now they have started because we moved the matter before the court. That's the whole issue, my lord. And they want that the petition should be infructuous.
And
By
before
calling
that,
the
Lordship,
witnesses.
inquiry officer has been,
Yes.
new inquiry officer. After the new inquiry officer has been taken charge, then the petitioner has moved this, Lordship. Why he has not moved it earlier? If this has been so, Lordship.
Why we'll move earlier? It is not on the advice of yours we'll move it. We know when to move it.
Whatever.
5th of
If
December
everyone takes, looks into
2023.
his own advantage, then
5th of
also the
December
government will also look
2023,
into
my
this
lord.
law.
Kindly see, my lord. 5th of December 2023, this notice what they have sent to us. 5th of December 2023 in the miss case.
And
When they have sent earlier, my lord. They have not sent it earlier.
and they have taken the ground. They have never said that these.
You
the
have
resolution is
examined,
Lordship.
you have are you posted with your instructions? Have you, you are making a
Lordship,
submission?
I have received on behalf of respondent number 5 only. And
Who is
for the,
respondent 5?
is
Director.
the director Lordship.
And where is the inquiry being conducted?
It is by the government Lordship. It is not before the director. It is
What
by
is the director to say?
Lordship, director to say his only thing, Lordship, regarding the financial benefits, Lordship, of the petitioner. And we also have information regarding the
Who is
earlier
to,
director.
who is
Lordship.
to give the instructions with regard to the status? Deputy Secretary.
Yes, Lordship.
Is it the Deputy Secretary?
Deputy Secretary, the Secretary, Lordship, whoever.
If you read,
1 to 4, Lordship.
if you see page number 16 in the IA,
Lordship.
it's a notice from the Deputy
It is
Secretary.
by the, yes, Lordship.
So you tell
Additional
us,
Secretary to the
you
government.
tell us on Thursday, when did the inquiry
Thursday.
commence?
Okay.
And at what stage is the inquiry?
Okay, Lord.
Mr. Das?
Only the 2 queries, Lordship, when the inquiry has commenced, Lordship.
And what is the status?
Status, present status.
Present stage.
Yes, Lordship.
Heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. H. Rahman and MS Bhattacharjee, Learned Additional Senior Government Advocate, appearing for the respondents. This IA is filed by the petitioner, praying for stay of the notice dated 5/12/2023 and the proceedings. You're praying for stay of the notice or for the proceedings also?
Proceeding on. Okay.
As well as the proceedings stated to be initiated against the petitioner. Departmental proceedings stated to be initiated against the petitioner. Stop. Learned Counsel, Senior Counsel for the petitioner submits that in WPC 6651/2023, filed by the petitioner, a challenge was made to the departmental proceeding initiated against the petitioner by issuance of a show cause, being show cause notice dated 17/11/2018. Stop. It is submitted by Mr. Das, Learned Senior Counsel, that this court on 18/11/2023, while issuing notice, permitted the respondents to file affidavit. Stop. Mr. Das submits that although not reflected in the order, it was understood at the bar that the affidavit would be filed and the matter can be heard, can be decided finally. Stop. However, contrary to the understanding of the Learned Senior Counsel, contrary to the understanding stated to have been given by the counsels representing the government in court, the impugned notice dated 5/12/2023 was issued directing the petitioner to appear before the concerned department on the date and time mentioned therein. Stop. Mr. Das submits that the show cause notice was issued as far back as 2018, and thereafter the petitioner filed his reply.
Yes.
Although the inquiry officer and presenting officers were appointed, no further proceeding was initiated, and the petitioner superannuated in the meantime. On when did he retire?
He retired on 30/11/2020.
30/11/2020. Stop. Pursuant thereto, the writ petition being WPC 6651 of 2023 was filed, putting to challenge the said inquiry proceedings. However, pursuant to the court issuing notice on 18/11/23, the impugned notice was issued requiring the petitioner to prefer the present IA. Where MS Bhattacharjee, learned senior government advocate, submits that the inquiry has already proceeded because there was no restraint given by the court in while issuing notice on 18/11/2023, and therefore the department is required to proceed with the inquiry and complete the same. And in accordance to that, the petitioner was put to notice to appear before the inquiry officer. So, whereas such submission made is disputed by the learned senior counsel on the ground that the inquiry did not proceed until the writ petition was filed, and it is on that basis there was an understanding that the writ petition could be disposed of after the counter affidavit is filed by the respondent. But be that as it may, considering the rival submissions in the matter, and also upon due perusal of the order dated 18/11/2023 passed in WPC 6651 of 2023, it appears that there was no interim order issued restraining the department from proceeding with the inquiry. Stop. However, the fact remains that the primary challenge in the writ petition 6651 of 2023 is with regard to the show cause notice and the disciplinary proceedings initiated against the petitioner. Under such circumstances, this court is of the view that the government be directed to obtain the instructions as to the date of actual initiation of the departmental inquiry against the petitioner and the present stage of the inquiry proceedings stated to be initiated against the petitioner. These instructions be placed before the court on, let us have it on Friday.
No.
Is it all right for you? Yes. Friday?
Right. Yes, sir. 12.
On Friday, 12th of January. Stop. Further orders, if required, will be passed upon perusal of the instructions as may be placed before the authority, before the court. Although notices are not issued in the IA at this stage, the advocate on record will furnish sufficient extra copies to the government to obtain the required instructions. You furnish copies of the IA, list on 12th for further orders.
Deeply obliged.
Sorry, my lord, I was on Lex, my lord, in court number 2, my lord.
No, not an issue. We want to know why the amount has not been released. He's asking
lord.
for some salary.
Yes, my lord. Lordship, we have filed 2 affidavits, my lord. Lordship may kindly take our first affidavit, my lord, filed by the Secretary of the Government, my lord, which starts from page number 38. Running page, my lord.
38.
Yes.
Yes.
Lordship may kindly come to paragraph 5, my lord. Page number 39.
No, we have seen, you have stated he's joined work for how many days? Yes, para.
Para 5, my lord.
Ah,
Then, my lord, page 40, relevant person I would like to place before.
yes,
lordship. 1, 2. 7th line, my lord.
yes.
One assistant engineer to physically inspect and verify the expenditure incurred under waste component of MNREGA. This is regarding, my lord, and one inquiry was done, my lord, against the petitioner, my lord. Thereafter, he was suspended, my lord. And after suspension, he was reinstated, my lord. And, my lord, he was posted at the present in a position, my lord, at Sapek IT, my lord. And that person, my lord, please paragraph number 7, my lord. Sorry, my lord, paragraph number 9, my lord. Next page, my lord. The 5th line, my lord. 5th line, my lord, page 42, paragraph 9. It may be mentioned that the BDO is the drawing and disbursing officer, DDO, my lord, of the petitioner for disbursal of his salary. Contents of the para relates to the office of the block development officer, Sapek IT development block, Soraido. If any employee does not perform his duty regularly and remain absent without authorization, he may not receive salary regularly. It may be further mentioned that, as stated in the contents of the para, letter dated 21/6/22 is not received as per record available in the department. However, as per report received from the block development officer, Sapek IT development block, while letter dated 24/6/22, the petitioner was not attending his duty regularly. This is one, my lord. And next, I have another affidavit filed by the BDO, my lord. Starts from page 92, my lord.
Yes.
Lordship may kindly come to page number 95. Paragraph 6. Yes. That contents of the paragraph 6 under reply is matter of record. It is humbly submitted that the respondent was never disagree or denied to accept the joining report of the petitioner on 27/12/2021. Rather, after joining at his office at the office of the block development officer, Sapek IT block, the petitioner never visit again to his concerned office for about 2 consecutive months. That is 9th day of March 2022, unauthorizedly, my lord. Then next paragraph, my lord, it is humbly submitted that the contents of the paragraph 7 under reply is a matter of record. It is further submitted that
He is an employee, he is working as what?
his post is, my lord, the extension officer credit, my lord,
Under?
under Panchayat and Rural Development Department, my lord.
So he's a government employee.
Yes, my lord. He is a government employee, my lord.
Now, with regard to his payment of area salary,
Yes, my lord.
merely because an officer is satisfied that he did not join, is it
lord, there is an office member, my
permissible
lord, of the
in
government,
law
my lord.
to stop his salary? Why have this not been included in the pleadings after filing 2 affidavits?
My lord, I have recently got this office memorandum, my lord.
No, this is not proper. Once you file affidavits, all pleadings, all documents are supposed to be there. Yes. This is 23.
Yes. But
Yes.
this will cover, my lord, in the last second page, my lord.
Hmm.
Next page. All cases, including pending cases till date, shall be regulated as per the instant.
No, what does it say? Let us
It
understand.
says, my lord,
Uh,
paragraph 2, in view of this, attention of all departments is invited to the various provisions of relevant rules as indicated in the following paragraph for strict adherence in situations of unauthorized absence of government servants. It is also suggested that these provisions may be brought to the notice to all the employees so as to highlight the consequences to be faced by the government servant on unauthorized absence to follow the relevant provisions of fundamental rules and FRSR regarding action to be taken on unauthorized absence, my lord. And provision of fundamental rules 17(1) says, my lord, the said provision stipulates that an
officer who is absent from duty without any authority
No,
shall
whose
not be,
satisfaction is required?
my lord.
Whose satisfaction will you arrive at a finding that he is been absent?
Yes, my lord.
Whose satisfaction?
It's the video, my lord, block development officer.
So
He,
he will decide whether an officer has attended duty or not, stop his salary.
my lord,
Is there no
he-
provision for causing an inquiry?
yes, my lord.
Then
He has already submitted and my lord, the inquiry, the so-called notice, my lord. He has not replied to that, my lord.
where is that show cause notice?
So-called notice is there, my lord. Page 45, my lord.
45.
Yes.
Page 45.
Yes, my lord. This is by government, my lord. Principal secretary. No, no, 45, punto.
He is the petitioner.
Yes, my lord. Suja Hussain Mazumdar is the petitioner, my lord.
Ah.
No, no.
You have not responded to this.
Sorry. This is the 2021 so-called notice, my lord. Sorry, my lord. Sorry, my lord. So this is the earlier so-called notice.
Then
Divided two. 102. 102, my lord. Sorry. Wrong affidavit. I have 102. 102, my lord.
102.
Next affidavit, 102. Running page, 102, my lord.
Ah. Against this, he has not submitted.
No, my lord. He has not. He has not submitted received. it. That I have stated in my reply, lord.
You have not?
Here, that notice, lordship, the cause has not been served to the petitioner, lordship. It was just, lordship, it was everything annexed in this affidavit is, lordship, after all, lordship.
How this notice was served upon the petitioner?
Because I have stated in reply. Lord. And page 150, lord. Page 150, middle lordship. Apart from that, although it is allegedly stated by the respondent number 4 that the deponent was all along absent from his office.
You find out from respondent 4 how this notice was served on him?
Yes.
What is the means?
Lordship, what happened, lordship? I have stated in my reply, lordship, some example, lordship. How, lordship, he was treated, lord. Kindly see, lord. Page 152, lordship. Roman 4, lord.
Yes.
The humble dependent begs to there are few examples which can easily prove that this fact that the copies of attendance register as annexing C and D in the counter affidavit of respondent are fabricated. Number 1A, it is clearly mentioned on the top of the annexed copies of registers that these are attendance register of teacher. My lord, he has framed some attendance register to place before this. B, in the annexed purported attendance, it is mentioned that in the month of April 2022, the deponent is absent present in the office only on 12/4/22. Whereas on 20/4/22, the deponent submitted an application praying for earned leave on medical grounds for the period of so and so, which was rejected by the respondent both with the marks as not allowed, putting his initial signature. If the deponent is absent in the office, then how he could submit his application? Also, how the respondent made his remark. I have annexed, lordship, annexure 1, lordship, in this petition.
You give us how this copy has been served.
Well, I'll take their instruction. And then, lordship, C, lordship.
Not only instructions, you show us from the records how it was served.
It was silent, my lord. The affidavit is silent, my lord. Another thing is, lordship, the respondent says that on 15/10/22,
Let us
work
see
order
from
was issued.
let us see from his records how it was served.
Yes.
You say it was never received.
No, lordship.
Let us see from the records.
Still the petitioner is. Paragraph 7 is the, my lord, annexure A, but it's not written here, my lord. The mode of the communication, my lord.
That we have seen.
And my lord, what happened in the attendance register? We have annexed the attendance register, my lord. Kindly see my reply, lordship, 160 page. this is the order.
No, how does this court find out whether your statement is correct or his statement is correct?
Yes,
On what basis?
Lordship, some examples I have given, they
No,
will clear.
examples are all right, Mr. Counsel, you have to make a legal submission.
Yeah.
How does the court find out?
Lordship, one example, Lordship, 160 page, Lordship. This is the order giving him allotted some duties. On 15/10/2020, he was given some work slot.
We are not on that.
Yeah.
We want to know whether the show cause notice at page number 102,
Yes.
annexure A, was served upon you, and if so, how?
How, Lordship?
And how have you responded it?
Yes, sir.
Mr. S. Dr. Learned Standing Counsel, PNRD, will obtain instructions as to the mode of service of the show cause notice dated 28/12/2022 within bracket annexure A, page 102 of the affidavit, 102. Now you write annexure A to the counter affidavit filed on behalf of respondent 4. Stop. These instructions are necessary as the affidavit, in the affidavit, it is stated that the said notice was served on the petitioner. Stop. The learned counsel for the petitioner, however, submits that no such notice was ever served, and therefore there was no question of submitting any reply to the said show cause notice. Accordingly, matter will be listed again on 5th of February.
Hello. Lordship, he is not getting his current salary also, Lordship.
Wait for some time. 5th of
Yes.
February, give us
He has two
instructions.
school-going children, and his wife is also I have a next, Lordship, is a psychiatric patient.
We can't pass an order today. So we want this information. Let it come on 5th of February.
My lord, I'll place it. High level.
It is a
Yes.
case of 2013, Lordship.
Huh?
It is a case of 2013,
Yes.
and all the petitioner and respondent has retired from service.
Then what remains? What is your prayer?
My prayer was that the selection that a post of additional senior to be stopped and the restoration of seniority. Now all have become.
So nothing remains there.
Nothing remains. But Lordship may not record that I could say the influx was. Lordship may record considering the fact that petitioner has retired from service.
Yes. Heard learned counsel for the parties. This writ petition was filed by the petitioner. Putting to challenge the promotion given to respondent, private respondent number 4.
To the post of superintendent engineer.
To the post of superintendent engineer
Hereafter the post of additional.
and to the next higher post of additional chief engineer in the Department of Public Health Engineering. Stop. Although readings have been exchanged in the writ petition, both the petitioner and the private respondent number 4 have superannuated in the meantime. Because unless we record your submission,
Already Lordship may record my submission retired from service. My submission.
no, retired from service, but
I have no
you are entitled to claim for notional if if we find that yes, your promotion was wrongly denied. But
Lordship, yesterday evening I tried to contact with my client regarding what is the state, what is the progress. They have not informed me, but that is why Lordship, I cannot say Lordship.
it is, we'll say the learned counsel for the petitioner has not received any instructions to pursue the matter any further, in spite of attempts made. Accordingly, writ petition stands dismissed as not pressed.
Closed, Lordship, closed, Lordship.
Closed.
Oh,
All
okay.
right, closed. Therefore, the writ petition is closed. Yes. Interim orders, if any, stands vacated. Learned counsel, so and so appears for the respondents. Exposed. Huh? Pending IAs are also dismissed.
Obliged.
Lordship heard the matter concluded. Lordship wanted the English version of the Hindi record. It has been placed.
We would like to dispose it off on the day we hear the matter, we'd like to dispose it off also.
The Lordship wants further hearing of the matter, my lord. You may fix a date so that
Whether that overstay of leave
Yeah.
was willful.
Yes,
That is the
one.
issue.
Yes. Last, my lord, they have not given the second show cause notice. And here, my lord, the petitioner was also declared as fugitive. Thereafter, no, my lord, suspension allowance, not possible for a person to. These are the points taken. Second show cause notice admittedly not given. And your lordship wants to see the record.
We wanted to see the records for
That second show cause notice given up. There is no
second show
communication.
cause is after before imposition of punishment.
Month. That has not been given.
No appeal was filed.
No. My lord, appeal was filed.
But all these were they taken up?
Yes, they have not. Appeal preferred. Page 72.
Where is the inquiry report? Inquiry report?
Enquiry report not given to us.
Is it available here?
It should be available in the record, but admittedly at the time of argument, in learned counsel for the government, my lord, said that it is not sent. Record doesn't reveal 7
Huh?
Lordship wants a list of dates I can prepare and give it.
Yes. You can prepare a list of date
Well, I'll do.
and you can add it over. We'll just keep it for one more day. In case we need any clarification, we can revert back.
Date may be given.
Yes.
In the meantime, I'll provide a list of dates.
Yes.
In Parivar.
Itu loh itu. Loh itu. Take out loh itu. Huh? Atau itu report. Records, you keep it with yourself. We have got a translated copy. Let us see if there's anything more required. in terms of the earlier order, the record, uh, the translated copy of the inquiry report has been received. Matter be listed for hearing on 6th of February. 6th of February
Well,
for
only the inquiry report, the other records relating to sending of the second inquiry, second show was nothing. That also your lordship wanted.
then the entire record will have to be translated.
No, your lordship wanted to see whether the second show was.
But these will have to be pointed out by the
council.
officer.
Because the last time when the matter
You
came up,
you point it out on the next day. You mark it, flag mark it, and point it out.
that your lordship may record, my lord, so that.
Relevant
specifically-
portions of the records available with the department be flag marked by the respondent council for perusal of the court if so required on the next date fixed. This on 6th
6th February.
February.
In the meantime, can I give the before the court master, my lord, the list of dates?
Yes,
or
yes.
Before that.
You are entitled to give a list of date, no problem.
May I please?
Yes.
The petitioner was serving as the assistant teacher in the upper primary school, my lord. What happened, my lord? He was transferred. And he
What is your prayer here?
prayer for release of my lord, settlement of pension, final pension.
Pension matters.
Yes, he has retired on 31/10/2021.
Hmm.
Let me just give the brief fact, my lord.
Yes.
The petitioner, my lord, was serving in his school since his appointment in provincial election 13/3/1987. And my lord, he was transferred in the year 2015. And he did not join. He preferred a writ petition before this honorable court. Ultimately, that case was dismissed. And thereafter, my lord, he intimated the authorities, but he was not given the place of posting, and he remained absent in the department, in the service. And he retired ultimately. And before his retirement, he made approach this honorable court earlier for extension of his joining time. This honorable court directed the authorities to consider his extension of joining time, and it was therefore rejected after his retirement. Now the position is that when he is getting the provisional pension, but the pension has not been finalized due to non-regularization of his gap period. Our prayer is that, my lord, it may be regularized and the pension may be settled for it. Because he has not been issued any shock cause, no disciplinary proceedings against him throughout the entire service period. But and on the other hand, he was not allowed to join also after intimation of the dismissal of the writ petition.
Who did not allow him to join?
Initially, he did not go. He preferred the writ petition for the stay of the transfer order, but it was rejected.
Hmm.
Thereafter, no further communication order has been made allowing him to join, because the initial order was for 1 month time. That is over.
Hmm. Then
Then he remained absent, my lord, and he retired as
he did not join.
he could not join thereafter.
No. Could not means?
Could not means after his dismissal of the writ petition, he was he intimated, but the authorities did not allow, because by this time more than 1 month period has gone by.
Hmm. Then he should have applied to the authority for extension.
He has applied, the extension of joining time applied, and that is rejected after and this honorable court has directed for consideration of extension of joining time. That is rejected. That is impugned here also. And he retired also. Rejected after his retirement. Rejected after his retirement, he retired on 31/10/2021.
Yes.
Now he, as per FR 18, my lord, authorities in such a, if someone is remains absent for long period, my lord, authorities are, if they want to take this, any action against the employee, has to follow the discipline and appeal rules or procedures as laid down by the, but that has not been opted by the authorities since is during entire period.
Yes.
And he retired also.
Evidently, my lord, there was no disciplinary posting. He was unauthorizedly absent, and it was more than 365 days. That is why his extension time was rejected under the finance OM, my lord. But now the position is that, my lord, he has retired from service. So now he is claiming for his final pension, my lord. Provisionally he is getting, he is claiming for final pension.
You have to regularize that period.
Yes, sir. That is why, my lord, may remand the matter to the secretary. Secretary will take a call on the attending tax and setup. Because that period has to be regularized, my lord.
What is there to take a call?
He will pass a revision order, my lord, regarding his entitlement, my lord.
What reasoned order?
He is entitled for pension otherwise.
That I am not disputing, my lord. That I am not disputing.
That
But some order has to pass, my lord, by the
director.
higher authority of the department, my lord. On the basis of that order, my lord,
Yes, this is director.
consequences will follow, my lord.
Yes, what do you say?
It has to be passed by the director, man. Director is the authority.
Director.
Director.
No, he says that the matter be remanded.
That with the direction to regularize that period and settle
So
this
that
pension.
direction has to be on the basis of some legal basis. You show us what provision.
Yes. FR 18, my lord.
What happened?
Yes.
FR 18 says, my lord, unless the governor, in view of special circumstances of the case, shall otherwise determine, after 5 years continuous absence from duty elsewhere than on foreign service in India, whether with or without leave, a government servant shall be removed from service after following the procedure laid down in Assam Services Discipline Appeal Rule 1954.
This is for removal.
This is for removal because he has not been removed. He has not been, my lord, no action has been taken against him, and he has completed pensionable service otherwise also, and he has retired, my lord, without any action. Therefore, he is entitled to pension, my lord.
No. You are supposed to go and join in
Yes.
a post.
We have submitted the application. This proposal was routed, and ultimately, with this honorable court directed the authorities to consider pass a extension of joining time and consider the extension of joining time. That is rejected after my retirement. It is rejected after my retirement. Had it been rejected earlier, had I been, my lord, subjected to any departmental prosecution proceedings earlier, that would be different, my lord. That nothing has been taken. His service has been provincialized with effect from 1/9/1986, my lord. And order was transfer order was 24/8/2015. He approached this honorable court, and this honorable
Refer
court.
to 105 joining time.
Pardon, Lordship? FR.
FR 108.
A government servant who does not join his post within his joining time is entitled to no pay or leave salary after the end of his joining time. Willful absence from duty after the expiry of joining time may be treated as misbehavior for the purpose of FR 15. That is there, my lord. That they have not taken recourse of that action, my lord. And there was no willful because he has intimated the proposal was also rooted.
Proposal
Yes, my lord.
by whom?
On proposal by the district officer, my lord, and so director, it is up to the level of government. It has been routed, my lord. For extension of joining time.
But it was rejected.
Ultimate after his retirement.
Now come to FR 17.
It is no work, no pay, my lord. I'm not no work, no pay. That period where I did not serve, my lord, that period payment may not be required, my lord. But the regularization and final settlement of the payment that may be done, my lord, without payment. Because
Okay,
FR 17 will not.
Heard learned counsels for the parties. This writ petition is filed by the petitioner, who is aggrieved by the fact that his pension has not been finalized. But you are asking for area salary.
The area salary for that period I served, that was not given.
As well as for the area salary for the period 15/1/2014 till 23/8/2015 and 25/8/2015 till 31/10/2021.
That may not be included, my lord. Otherwise, it will be amounting to entire period that I did not serve. That second part.
You served during which period?
That first period, my lord. 15/1/24 to for 2014 to 23/8/2015.
No, let it remain. Let it remain both the periods. So the learned counsel for the petitioner submits that petitioner was transferred by. Is the transfer order here?
Yes, sir. Transferred on
Page number, transfer order.
transferred.
27A.
20.
Was transferred by
27.
Order dated
24/8/2015.
24/8/2015. Stop. Then what happened?
Then, my lord, he preferred a writ petition, my lord, that is dismissed. And that is dismissed on, my lord, 27.
No, he was transferred. He did not join.
He did not join.
Filed a writ
Writ
petition.
petition.
After issuance of the transfer order, petitioner approached his court filing present writ petition. Not present,
No,
earlier
earlier,
writ
earlier,
petition.
my lord.
Writ
In
petition,
application number, my lord, 526 of
35.
5/26, 2017.
5/26, 2017.
It is dismissed
Which
on, my
was
lord,
subsequent, which was eventually dismissed
by order dated, my lord, 27/8/2018.
by order dated 27/8/2018. Stop. Thereafter, the petitioner uh, proceeded to join in his place of posting, but he was not allowed to join on the ground that the joining joining period indicated in
Is expired.
the order had expired. Stop. He submitted several applications before the competent authority, and on the basis thereof, a proposal was also forwarded to the competent authority for extension of joining time.
I ordered forwarding letter date 24th September 2021.
Doesn't matter. However, then where was it rejected?
It was rejected, my lord, 31/10/2022.
Page number.
Page number 63A.
Subsequently, it was rejected by order dated 31/10/2022. The proposal for extension of time was rejected by order dated 31/10/2022.
And follow-up order dated issued by the 12/12/2022, my lord, by the director. Follow-up.
Follow-up for
First one by the government, second one by the director, my lord. 12/12/2022.
by the Undersecretary, issued by the Department of School Education. Stop. This was followed by the subsequent order communicating the subsequent order issued on the basis of the order issued by the Department of School Education. This was followed by the subsequent order dated 12 December 2022 issued by the Director Elementary Education in terms of the earlier order issued by the Department of School Education. Stop. Learned Counsel for the petitioner submits that although the petitioner filed necessary applications for extension of his joining time and a proposal thereof was also forwarded to the competent authority. However, since no intimation was received from the competent department, the petitioner was not permitted to join. And in the meantime, he superannuated on
31/10/2021.
31/10/2021. Stop. Learned Counsel submits that it is only pursuant to his superannuation that by order dated 31/10/2022 that the Department of School Education rejected the proposal for extension of joining time. Stop. As a consequence thereof, since his period of absence from duty has not been regularized, his pensionary benefits have not been finalized. Stop. Learned Counsel for the petitioner submits that at present he is receiving provisional pension, but his
Other pensionary benefit, including MSCF,
other
MSCPS,
retirement and pensionary benefits have not been released on the ground that
including MSCPS, my lord.
Including
MSCPS.
MSCPS, on the ground that his period of service has not been regularized. Period of absence has not been regularized. Learned Counsel, Standing Counsel for the Education Department submits that the affidavit on behalf of the department has been filed, and it is averments are made there that the petitioner did not join in his place of posting, and the period of joining time mentioned in the order of transfer had expired and therefore there was no scope for the respondent authority to permit the petitioner to join. Stop. The subsequent proposal for extension of joining time also came to be rejected. And therefore, the pensionary, the pension papers could not be finalized. Stop. Having heard learned counsel for the parties and upon careful perusal of the pleadings on record, why it is seen that there is no dispute that the petitioner did not join within the time specified, and consequently he was not permitted to join. However, the proposal which was put up before the department for extension of the joining time came to be rejected on 31/10/2022, which is 1 year after the petitioner superannuated. Stop. Under such circumstances, unless the period of absence is regularized in terms of the rules and procedure, the petitioner's claim for pensionary benefits will cannot be settled. Stop. There is no dispute that that no proceedings, no departmental proceedings have been initiated against the petitioner on the ground that he had failed to join in his place of posting in terms of the transfer order. Stop. No show cause notice or inquiry to that effect was initiated against the department, against the petitioner. Under such circumstances, unless a proceeding is arrived at, and unless a proceeding is initiated and findings thereon are arrived at conclusively by the competent authority, the non-release of the area salary and the pensionary benefits cannot be withheld. Stop. There is no dispute that the petitioner is a government servant. Is he is what, a provincialized teacher?
Yes, yes.
Is a teacher provincialized as per the provision of law, and therefore is entitled, and his services and his service, and he rendered his service and is therefore entitled to the pensionary benefits as per provision of law. However, because of the non-regularization of the period of absence, the pensionary benefits could not be released. Stop. Under such circumstances, we deem it inappropriate to remand the matter back to the Director Secondary Elementary Education to inquire inquire into the matter and pass appropriate orders. Inquire into the matters to verify and inquire, and if no such disciplinary proceedings are pending and no orders post any such disciplinary proceedings have been passed by the department, the period of service for the petitioner, period of absence of the petitioner be regularized, enabling him to receive his pensionary and retirement benefits. Stop. The director will also make necessary verification into the claims of the petitioner for area salary.
And MSc.
Stop. It is made clear that for the period the petitioner has worked, he would be entitled for the area salary, but for the period which the petitioner did not render service, his claim for area salary cannot be entertained on the principle of no work, no pay. In terms of the above, writ petition stands disposed of. The directions contained above shall be carried out by the director within a period of
2 months, my lord.
60 days from the date of receipt of a certified copy of this order. Writ petition stands disposed of in terms of the above.